from taking this test case item 3, 2nd April 78 of 1999.
Only one thing, Your Lordship. We may be stuck on certain fact because नहीं
एकदम नहीं आपको टाइम नहीं
हाँ वो ठीक है हम टाइम नहीं ले रहे हैं इसमें LCR नहीं है मतलब जो evidences required है नहीं है that I may be allowed to place it from the impugned order itself and it may because
you see normally there is no scope for reappreciation of
ठीक है
evidence.
I'll keep myself confined.
You keep myself अगर मान लीजिए इनको लगेगा कि कोई चीज गलत रिकॉर्डिंग है impugned order में you can always point out that this has been wrongly recorded.
ठीक है
इसमें तो कोई दिक्कत
But
नहीं
only
है.
one intelligence from your lordship, Lord Mr. Gupta will conclude.
नहीं आज हम आपको सुनेंगे पूरा प्लीज
Lord, हमको Lord खाली कल
नहीं नहीं आई एम जस्ट टेलिंग यू
Yes.
आई विल नॉट डू दिस. आप साथ साथ पढ़िए ये नहीं होगा क्योंकि दीज मैटर्स आर वेरी ओल्ड मैटर्स. हमको भी बहुत टाइम लगता है चीज़ों को समझने में और हमको पढ़ना पड़ता है. हम जो है इतना हमको मेंटल कैपेसिटी नहीं है, इतने इंटेलिजेंट हम नहीं है कि आपके बाद वाला सेकेंड अपील हम बिना पढ़े करेंगे. एंड एक असेसमेंट होता है भाई आज हम ये सेकेंड अपील में हमको 1 घंटा टाइम लगेगा तो उसी अनुसार हम लोग तैयार होकर आते हैं ना.
But definitely Lord.
नहीं
But
इतना
हमको
नहीं ये नहीं होगा. आप यू जस्ट स्टार्ट योर राइटिंग.
Yes, I will start Lord, but
नहीं
खाली हमको conclude करने के लिए कल
नहीं.
के लिए थोड़ा टाइम दे दीजिएगा बस Lord. Nothing more.
हाँ बहस कर लिया. फाउंडेशनल फैक्ट्स आप दे दीजिए जिसमें अनडिस्प्यूटेड फैक्ट्स यू कैन प्रोवाइड.
Your Lordship may see we are actually now concerned with the question of law that was framed. It was with regard to constructive knowledge of whether because the respondent hearing is the person who is claiming on the basis of 2 registered deeds of sale. So the only question of law that was now framed was because they had challenged the validity and they had also said that the agreement was forged and all those things were there, but those have been turned down by the courts below. Now the validity or that the agreement was executed between the plaintiff and the defendant number 1, who was the original landowner, is not in dispute. So only thing now, therefore this question would now fall for consideration is whether because they are claiming the date of agreement is 5/8/1979 and the sale deed are dated 25/1/1980. 2 sale deeds by defendant number 1 in favor of defendant number 2 and 3. And one
Just
more.
a moment.
Yes.
Number 2 and
And 3.
who was in possession?
I was in possession. So why I say this, Your Lordship, undisputed fact is that
You are the plaintiff.
plaintiff.
You are the plaintiff.
Yes, I am the original plaintiff who had filed a suit for specific purpose. Now I have already stated that defendant number 1 owned a large chunk of land, and out of that she had already executed 2 deeds in my favor with regard to different portion of the same property which belonged to her. And those deeds were of the year 1973 and 76. This is important for some other reason which I will subsequently. So prior to entering into an agreement in 1979, the defendant number 1, who was the original landowner, had already executed two sale deeds with regard to two different portions of the property in the year 1973 and 76. One is in the favor of plaintiff and another is in favor of his own bhabi or some relative of the same family. In 1981, the plaintiff files a suit for specific purpose.
Initially, they were made party. Right from beginning, they were made party.
Yes, yes, they are made. They were made.
It is not a subsequent development which came
No.
of it.
They were made. Your Lordship, in just before filing of suit for specific performance, another suit was filed, which was numbered as title suit number 69 of 1980. It was numbered as title suit number 69 of 1980 and it was filed by, we had filed a suit in which the same vendor, that means defendant number 1, had filed a written statement which is exhibit 14. This will be.
Just a minute. In this defendant number 1,
One.
was
Vendor.
the defendant number 1 there also?
There also.
Vendor.
She had filed a written statement,
What was the suit for?
suit for permanent injunction.
Exhibit
14 is her written statement because she
निकालिए,
did,
exhibit 14 निकालिए.
because she did not appear in the instant suit, the vendor, and they have contested.
She was alive that time.
Yes.
You see, whether what the vendor was doing is immaterial, considering the question of law.
Yes.
What is important is whether they had knowledge about
Yes,
the
yes.
previous.
For some reason I am placing all these because the vendor, in her written statement in another suit, which was instituted prior to this, she has very categorically stated that she had informed the purchaser about the pendency of the of the agreement with us. This statement is there. One affidavit it is there, and she says that she had entered into a mortgage and they had misled her into executing a deed of sale, and she also says that consideration amount had not passed. Now this fact
Which
is,
is that paragraph?
yes, Lordship may see the written statement of defendant number 3 in that. Yes. This is exhibit 14.
This
Your
is
Lordship.
para number.
Para number 3, next page, page 2.
Yes.
That the defendant number 1, Sarfi Lal Sahu, was fully aware of the aforesaid sale and agreement. And what is that aforesaid sale and agreement? That has been mentioned in para 2. So I may be allowed to place para 2 also.
Yes.
It is true that this defendant, as owner of plot number 597, sold away certain portions of the said plot to the plaintiffs as mentioned in para 3 and 4 of the said plot to plaintiffs as mentioned in para 3 and 4 of the plan and shown in the map in schedule A1 and A2 thereof, and which are continuing in possession of the plaintiff. it is also true that this defendant wants to sell to the plaintiff remaining portion of plot number 597 after she could complete her arrangement to shift from the remaining portion of the house where she is living to another place. Accordingly, on 5/8/1979, this defendant executed an agreement for sale of Schedule B properties to the plaintiff Sobhag Malyan for rupees 40,000, out of which an advance of 1,01,000 was taken, as this defendant wanted to have sufficient time, that is 2 years, to vacate the building and premises of Schedule B. That the defendant number 1, Ashrafi Lal Sahu, was fully aware of the aforesaid sale and agreement. He had developed intimacy with the sons of this defendant, and as subsequent events show, they took undue advantage of the simplicity of this defendant by winning over her sons. In the third week of January 1980, this defendant was in urgent need of sufficient money for purchase of land and material from defendant number 1, offered to give her 20,000 against simple mortgage of Schedule B properties, about which there was already an agreement for sale with the plaintiff number 3. On being reminded of the aforesaid above fact, defendant number 1 stated that there was no harm in creating a mortgage, as there was sufficient time for the sale with the plaintiff number 3 to materialize and to complete the preparation of vacating the premises finally. These talks had taken place in presence of Sirajuddin, the son-in-law of the defendant, and Enamul Haq, defendant number 4. On 25/1/1980, this defendant was made to sign certain document, contents whereof were neither read over nor explained to her. She was neither informed that these documents were sale deed and not rehans, which she had agreed to execute. The defendant number 1 himself took out certain stamps, selected his own scribe and witnesses, and it appears that he had now influenced and won over her sons, who too did not explain the nature and character of the transaction. In short, the defendant number 1, in collusion with some of the sons of this defendant, obviously for monetary gain, misrepresentation and fraud, made her to put LTI on the two purported deeds in favor of defendant number 1 and 2, which she never intended nor she could do in view of already subsisting agreement with the plaintiff. Then, para 4, after approximately 10 lines, from the plaintiff, she could know that the document dated 25/1/1980 was sale deeds and not mortgages, and the consideration amount shown there was rupees 45,000, whereas in reality only 20,000 had been paid to her. The recitals of the so-called sale deeds are wrong and many regards. So here I'll pause, Your Lordship. The statement that total consideration amount was 45,000, but in reality 20,000 only had been paid to her, is also admitted fact by the defendant number 2.
So
Which
the
I'll
entire
show.
consideration for the sale deed was also not paid.
Yes, not paid, and they have admitted in their written statement of this particular suit itself. That I'll show. Now, Your Lordship, then Your Lordship may kindly come to their own written statement. Therefore, I was placing this line. Now, their own written statement in the instant suit itself, that Your Lordship may kindly see, is it is there in
ये देखिए उसमें
main written statement जो इस सूट का है, इस सूट का।
ये ऑर्डर में नहीं रिकॉर्डेड है स्टैम्प
हाँ यार recorded।
उसी से दिखाइए ना
अच्छा
unless there is an error
अच्छा,
in
ठीक।
recording we need not
ठीक है, हम दिखाते हैं।
क्योंकि ये जो है ना छूने से ही फट जाएगा ट्रायल कोर्ट का जजमेंट में तो पूरा ही लिखा होगा डिफेंडेंट नंबर 1 हैज नॉट फाइल्ड रिटन स्टेटमेंट नॉर दे आर कंटेस्टिंग द सूट केस ऑफ डिफेंडेंट पैरा 5 ऑफ द ट्रायल कोर्ट
हम एक बार रिटन स्टेटमेंट पढ़ दे रहे हैं, इस बीच में रेलेवेंट
ठीक
इसमें से देखो। Para 17, I'm just reading, and then para 17 of the written statement of defendant number 2 and 3, who are the contesting subsequent purchases. that the defendant number 1 has executed 2 sale deeds, both dated 25/1/1980, are in favor of Sharfi Lal Sahu, defendant number 2, being deed number so and so, and the other in favor of Srimati Chanda Kanta Devi, defendant number 3, his own wife, being deed number so and so. Both the deeds are registered. The consideration for the sale for deed number 759 is rupees 20,000 only, and the deed number 760 is 25,000. Out of the consideration money, rupees 10,000 in each of the sale deed had been paid to the vendor by the respective vendees before the district sub-registrar Hazaribagh, and the balance amount of the deed number 759 in favor of defendant number 2 has been paid, for which separate receipts have been granted. Out of the balance amount of rupees 760 in favor of defendant number 3, only 10,000 has been paid, for which separate receipt has been granted. The balance amount of rupees 5,000, the defendant number 3 is ready but to pay, but the defendant number 1 has not asked for that, as she has not vacated one room as yet. So therefore, two things. On the date when the sale deeds were being executed, admittedly the statement of defendant number 1 that she was paid only 20,000 is absolutely established. And the defendant number 2 and 3 also admit that on the date when the deed was being registered, they had paid only 10,000 in 20,000 in all. And subsequent to the sale deed, they say that 10,000 and 10,000 more were paid and separate receipts.
But still the entire amount was not paid.
Yes, that is my submission. And according to admission of the defendant themselves, the purchaser, so-called bona fide. So why I place this? Now, Your Lordship, if a subsequent purchaser is there, he is protected, he is otherwise bound by the terms of the agreement. So, because if he is purchasing a property subsequent to the agreement, then he is bound to by the terms of the agreement, and he cannot escape the binding effect of a earlier agreement. He can only escape if he satisfies the terms of section 19(1)(b), which is of the specific meaning. Now that lays down two conditions. First, it says that Your Lordship may allow me to place that.
Specific reading faculty. It is bona fide purchaser for consideration.
For consideration. So, bona fide for value, it has to be there. So, he has to show bona fide in purchasing the property, and then it also says except as otherwise provided by this chapter, specific performance of the contract may be enforced against either party thereto, any other person claiming under him by a title arising subsequently to the contract, except a transferee for value who has paid his money in good faith and without notice of the original contract. So here they can only escape this only if they establish that they are transferees for value who have paid money in good faith. So this they have to establish first condition, that here they have not paid the entire consideration amount mentioned in the deed itself. The value they have not paid. So they cannot say that it was in good faith.
But that is not the question.
No, but Your Lordship, why? Because ultimately, whether they had constructive knowledge or not, this is a connecting factor. So, because they would be escaping the liability they can take advantage of section. Whole purpose of framing of that substantial question of law is that whether they are bona fide purchasers or not, and whether they have constructive knowledge of. So ultimately they have to establish the condition of section 19, because this is connected to the question already formulated. Here, therefore, Your Lordship, they have to show
Their
that.
sale deed is exhibit.
Yes. Exhibit Which exhibit your lordship want to put?
Their same.
Their same. Exhibit A.
5 by 8.
5 and 5 by 8. नहीं ये तो
Exhibit 5 तो यहाँ दिख ही नहीं रहा. 5 by 8.
But exhibit A and A by 1.
This is dated January 25th, 1980. By B.B. Sullivan to Sarfilal Sahu and his wife Chandrakanta.
So according to you, this is an important circumstance to show that they had knowledge.
Yes, and their purchase was not bona fide. Why it was not bona fide? Because they had constructive knowledge about the agreement, prior agreement. Now, another important fact would be defendant DW11 is defendant number 1 himself,
Yes.
and his admission is mentioned by the trial court. Your Lordship may see from the trial court's judgment that, taking note of that, the trial court held that the defendant had knowledge about the prior act. And Your Lordship, page 28, which Your Lordship wanted to know what was the, with regard to the two salvage, the entire consideration amount had not been paid. It is there in page 28, and then page 26 is issue number 5 and 6. Issue number 5 was with regard to constructive knowledge. And page 27 of the trial court judgment, this has been observed by the trial court. It is probably handwritten here.
Yes.
Uh,
The plaintiff is admittedly in possession of A and B lands.
Third paragraph of issue number 5 and 6 by the trial court. by the trial court.
Yes, I'm at the trial court judgment.
Third paragraph, where it says DW11, Asharfi Lal Sahu,
Yes.
has stated in his cross-examination that he has not disclosed about his purchase. He made no inquiry about the land. This is very important. He made no inquiry about the land. He has also stated that he asked his wife not to disclose about the sale deed. This is a circumstance against the defendant number 2 and 3, and it supports the case of the plaintiff that the defendant number 2 and 3 had full knowledge about the previous agreement between plaintiff and defendant. So therefore, this also shows that they had not bona fide. It was a transferee. They were not a transferee bona fide, and they had constructive knowledge about the execution of a prior.
This conduct.
Yes, absolutely. And then next page, Your Lordship may kindly turn where this particular fact in the next paragraph has been mentioned. I may be allowed to read
Yes,
from
please.
next page. The plaintiff is admittedly in possession of block A and B land, and it was proper to inquire about the land by plaintiff at the time of purchase by the defendant number 2, but it was not done. It shows that intention of the defendant number 2 and 3 was not fair. It must be bona fide. It was not bona fide at the time of purchase. Other witnesses examined by defendant is of no importance because they have stated about the possession of the defendant number 2 and 3, but the fact is admitted. There is another strong circumstance to support the case of the plaintiff that the defendant number 2 and 3 has not made full payment of the consideration at the time of execution of his sale deed. On the date of execution of the sale deed, only rupees 20,000, rupees 10,000 for each sale deed were paid, and they were not put in possession of the land on that day. At the time of execution of the sale deed, Bibi Saliman was in possession of the land and house, and according to the case of the defendant number 2 and 3, have bought possession after 25 days over one portion of the house. When they made payment of the remaining consideration amount on different date, they were put in possession of the entire house. It is also a circumstance in favor of the plaintiff that the sale deed obtained by defendant number 2 and 3 has not been obtained after payment of consideration.
What about the appellate?
Then,
When does the transaction complete?
when is the transaction complete? Your Lordship, one more. There is another appeal which is in today's list. That same point of law would be very important for deciding another case. So that particular case may be heard on some other day, but
No, because there is a deferred payment.
deferred payment. So under section 54, because there are two judgments of Honorable Supreme Court, I must disclose everything. In one judgment, it was said that if there was promise to pay at a future date, then that would be a complete sale. That where I am promising that I am transferring the property to you, and the purchaser is promising in the sale deed itself that I will pay on a deferred date, but that promise is there, then that sale is complete. But that
Then
sale,
in that circumstances also, if the payment is not made, the remedy is specific performance of contract.
yes,
Then
that
the
is,
remedy would be specific performance of contract, that this much of amount is yet to be paid,
yes,
and as per the sale deed, it is a deferred payment not having been paid. Now there is a specific performance of contract to that
yes,
effect.
yes. But there are many cases that are coming. For that I was saying that Your Lordship, any law laid down by Honorable Court would have an impact there. Many cases where the consideration, this is not a case, I will not say that, in which the sale deeds are being executed and absolutely on a false pretense, then what would happen? Whether the owner of the property, can he be compelled to go to the court seeking the amount in? Because the basic
The section 16 cast a burden something more than mere execution of security. The language says what is
section
it?
16 of 19 of
specifically.
yes.
Transferee for value who has paid in his money in good faith
Yes.
and without notice of the original
Both
contract.
second condition is also important.
So, value has to be paid in good faith. The money has to be paid, has paid the value.
Yes.
So, have they given any date regarding payment, subsequent payment? Any specific date given?
That.
Because that will have a bearing in the matter.
Exactly. Receipts. Because they themselves say that they had subsequently paid.
Yes. Have they given any date, any receipt produced? Defendant number 1 is not contesting.
Yes.
She has not filed written statement to say whether she has received the entire amount or not.
She does not say.
She does not say.
Rather, in another suit, her affidavit statement is there that she was not paid the only paid 20. It is
Not B and B by 1.
B.
What
B
is the date
series
of
है.
payment?
B series है.
B and B by 1.
Yes.
नहीं चार पाँच.
नहीं, देखिए ना, exhibit B receipt of payment executed by B.V. Salima in favor of Shaktilal Sahu dated 21/2/80 and exhibit B by 1 is received dated 7/4/81.
I have at least 5 dates. 21/2/1980, 7/4.
B मतलब B series है, B series है.
Subsequent payment.
Yes, sir, subsequent. And it is our case note that after said date we have been delivered possession. After 25 days after payment of the entire.
After payment.
After payment of the entire.
Fair.
Entire amount, then also entire amount is not there, because in the written statement themselves they say that 5,000 is still remaining.
Which they are ready to pay and she is not
Yes,
ready
yes.
to accept. If she asks
Yes.
it, then we will pay. This is with respect to both the sale deeds. 5,000 yet to be paid, or it is in connection with only one of the sale.
5,000.
It is not a joint purchase. Anyways, let us see this. What is the finding of the learned appellate court, and has the appellate court dealt with this reasoning given by the learned family? These two things we need to see.
Yes. This point has been discussed in page 29 of the
It starts
appellate.
from para number 7 or page 29. Okay, let us come to page 29.
Para 16.
Okay, yes. Para 14, it starts all the issues to 1, 2, 3 and 7. Point number 7. Okay.
It's because agreement was also challenged, but this
Yes.
particular finding with regard to notice is there in para 16.
Para 16. Yes, yes, next point.
The next point for determination is whether the subsequent purchaser, that is defendant appellant, had notice of prior agreement under section 19 of Specific Relief Act. A contract is specifically enforceable against either party to the contract except a bona fide purchaser for value without notice of previous transfer. The defendant appellants, after appearing in the suit, not only challenge the genuineness of the agreement to sale, they had also averred that they had no notice of the said agreement. Only they had, it would be they had notice of the said agreement only.
Not only.
Not.
Achha, no notice of the agreement, not only prior to the execution of the sale deed and their registration, they had no notice of this fact prior to institution of the suit, that is title suit number 69 of 1980. The plaintiff respondent have on the other hand,
When was this instituted? Title suit number 69 of 80. Because one payment is 1981.
81 is there.
So they say that they had no knowledge prior to institution of title suit number 69 of 80. Certainly it must have been instituted in 1980 itself.
Yes, absolutely. That
Right.
is not in this.
But this is 2799.
Sorry?
2799. 2nd of July 19.
It is 2/7/1980. But part payment is made on 7/8/81. 7/4/81
Yes.
with respect to one of the claim.
Yes.
Continue please, the plaintiff respondent.
The plaintiff respondent have on the other hand produced evidence to prove prior notice. As to evidence of the plaintiff respondent, they have not produced any document prior to institution of the suit to show that the defendant appellant had notice of the execution of the agreement. So far as the original evidence, so far as oral evidence of the witnesses is concerned, when I look to the evidence of the witnesses examined on behalf of the plaintiff respondent number 1, I find that except PW 8, 12, 11, 12 and 19, no one has examined to support the defendant respondents had knowledge of the execution of the agreement. The evidence of PW 14 and 15 on pleader of the two pleader commissioners who had measured the portion of the properties in possession of the plaintiff respondent was not sufficient to help the plea of the notice to the defendant appellant of the prior agreement, either actual or constructive. PW 19 of the plaintiff, in his evidence in paras 27, has asserted that assumed that the defendant number 2 and 3 had knowledge of the agreement between him and Bibi Salima. PW 8 is a mason who had asserted before the lower court that he had constructed 3 pillars on the disputed land on the southern side of the land of Subhagmal Dam, where a small godown was situated measuring 80-61 feet long from north to south, but period of construction according to him was 75-76, and as stated in para 2 of his evidence, PW 12, PW 11 has asserted that in the month of August 1979, on Sunday he had gone to Baiju Bhav, Asarpi Lal Sahu, defendant number 2, where he had found that Subhagmal Jain, Mahadev Lal, Anmol Haq and other persons were present in the disputed shop. It is not clear as to which shop it was called the disputed shop. Asarpi Lal Sahu had inquired from them as to why they had assembled there. Mahadev Lal had informed him that a portion of the house had already been sold and the remaining portion was going to be sold through an agreement. The agreement was going to be scribed, and so they were waiting for Munshi. After 10-15 minutes, Munshi arrived there and all of them went inside the house. It is also asserted by him that he had gone to Baiju Babu for some accounting, but no such accounting had been specified. It is admitted by him that he had not talked with Asarpi Lal about agreement. It is also admitted by this witness that there was no negotiation regarding agreement nor regarding payment before him. It is not clear as to how and where he met Asarpi Lal Sahu. So, evidence of this witness regarding knowledge to defendant number 2 about the alleged talk of agreement does not appear to be truthful. Simply asserting that sometime in the month of August he was
Asarpi Lal Sahu is the
defendant, one of the purchaser.
one of the purchasers.
one of the party himself.
Yes, yes. Different number 2 and 3. Yes, continue.
Simply asserting that sometime in the month of August he was accompanied by Asarfi Lal and so knowledge of agreement between Saliman and plaintiff respondent would be imputed to defendant number 2 does not appear to be reasonable. The evidence must be direct to impute actual knowledge of such fact to the person and it must be asserted with certainty by the witness. Here are all. The entire thing is being shifted on me. Also, it is otherwise erroneous in view of the law laid down by Honorable.
Yes.
The evidence of PW1 therefore is not sufficient to impute knowledge of scribing of agreement. Neither it is general, rather it is general and vague. At the same time, the plaintiff has not produced any evidence, oral or documentary, that Chandrakanta Devi had knowledge about the agreement when she got the land of Khata number 597 mentioned in blocks C and E, executed by B.B. Saliman on 25/1/1980. It is therefore not established that the defendant appellant had actual knowledge of the execution of the agreement of sale of the disputed land prior to date of execution of 2 registered deeds of sale in their favor. The plaintiff respondent has also pleaded constructive notice of the transaction to dependent respondent on the basis of alleged delivery of possession in their favor, particular area, that is 7 feet by 7 feet, mentioned in Exhibit 7, sketch map attached to the plaint. This fact has been asserted in the plaint implicitly. It would be emphatically denied by the defendant respondent, but no separate issue regarding notice of agreement, either of actual or constructive, had been framed by the learned lower court. It was very vital issue, and so it should have been separately framed and adjudicated. I have found that the evidence actual notice was not sufficient. As to constructive notice, possession over a portion of disputed land was said to give constructive notice to the appellant that the lands they were going to purchase was not free from any encumbrance. Here it should be noted that
Most important
would have been
the
the evidence of P.B. Saliman, who neither appeared nor filed written statement in the suit, stating that she had executed an agreement for sale after receiving concession money and
Just
delivery.
pause here for a moment. As to constructive notice, possession over a portion of the disputed land, whose possession are they talking about?
My possession. My partial possession.
You had partial possession?
Yes. This is my plea, that I was in possession of 7 feet by 7 feet of land, which is a portion of it, which they deny. So this is being discussed by the trial.
Continue, please.
By the appellant. Now here, Your Lordship may see, here it should be noted that the most important would have been the evidence of B.B. Saliman, who neither appeared nor filed written statement in the suit, stating that she had executed agreement for sale after receiving consideration money and she had delivered possession of so. So here I'll pause, Your Lordship. Here, once the appellate court and the trial court both concur that there was a valid agreement executed between the parties, this could not, the appellate court could not have said that I was required to. She did not come for evidence. Because
Why would she? Her conduct is under cloud.
Absolutely. And
her non-examination would help whom?
It would help me because if her statement is already there on record. So if any person was contradicting her statement, it was for them to have brought her or to have got her summoned through the process of the court. Because otherwise I had already brought an evidence in the shape of a written statement where she admits everything in my favor.
Anyways, I will continue.
Yes. And she had delivered possession of small fraction of land to the plaintiff for extension of godown and this fact was well within the knowledge of the defendant. A written statement has been produced and proved in this case on behalf of the plaintiff respondent, and it has been asserted in title suit number 6980. Through this written statement, BP Saliman, who was one of the defendants, had admitted that she had earlier executed a sale deed and that defendant number 2 and 3 had obtained her LTI in two purported deeds in their favor, which was never intended nor to be done in view of the agreement in favor of plaintiff. She is also said to have stated in the said written statement that Shakti Lal Sahu, the defendant in that suit and appellant predecessor in interest, was fully aware of the agreement, and in collusion with her son, her son got these documents prepared and got them executed on 25/1/1980. It is mentioned.
This agreement dated 25/1/1980. Here he says that this shows that there was a collusion. Is there any finding of collusion?
There is no finding.
The agreement has been held to be valid.
No, but 25.
It has been held to be valid.
25
So
was
this is the sale deed. Did they? You see, Salima did not appear. This particular sale deed being collusive with her son, was that your case? Whose case was this? That there was a collusion with her son? With the son of
with her
anybody?
sons with regard to the sale deed.
Yes.
This was not pleaded
It was not case.
because our
Then
case.
why this court is entering?
No,
into
why
that?
our case was that this is all connected to the constructive notice that we tried to establish the fact that this was not bona fide, and therefore they could not have taken advantage of section 19(1)(d), and therefore all these connected facts are.
Okay, read further. It is
She was-
mentioned.
She was in impression that there were rehans in which she had agreed to execute in favor of defendant is because the defendant had agreed to pay her 20,000 as mortgage money and she was in need of money. Relying upon assertion, the plaintiff responding counsel has contended that this document being admission of vendor of the defendant appellant was admissible against them. In my opinion, the written statement of B.P. Saliman, even if taken to be genuine, she could not have, the learned lower appellate court could not have said that even if taken to be genuine, because this could not have been genuine. Even if taken to be genuine, one cannot be used against these appellants. The reason is obvious that under section 18 of Evidence Act, statement made by person from whom parties to the suit have derived interest in subject matter of the suit are admission if they are made during continuance of the interest of the person making the statement. In the instant case, Exhibit 14 has been filed on 11/8/1983 when B.P. Saliman, defendant number 3, had already parted with the property in question. Hence, such statement cannot be received as admission against the person to divert the right of such person claiming under the person making such admission according to her choice. In this connection, page 3 so and so of the Sarkar evidence may be referred where there is decision upon so and so 1923 has been mentioned. It has been reported that a purchaser is not bound by the admission of the vendor where subsequent to the purchase.
So Exhibit 14 has been rightly taken care of.
Exhibit 14
Has been rightly taken care of.
has
Was there
been
error
rightly-
in this file?
No, my
Because this
submission.
particular submission is taking care of Exhibit 14,
Yes.
right?
My
She is not present in the court. She is not filing a written statement. You can impute malafide on her, but how do you impute malafide or maybe lack of bona fide so far as the purchasers are concerned?
Yes, because first she makes her statement is absolutely clear. Let us assume that it is a post sale by her, post execution of the sale deed by her, but in the written statement itself, those two statements are absolutely, they are being connected together. first statement by defendant number, the original vendor, that she was paid only 20,000.
That is the written statement here.
Yes, in the original written statement,
Yes.
in the 1980. So once she says that the Asarfi or the defendants had actually knowledge about the agreement, and then if her statement is already there that this particular fact was, the appellate could not have discarded. If she says, now rest all other statement I could understand, but if she says her statement to the effect that the purchasers had knowledge about the agreement, this could not have been discarded. Now if a person, if the defendant number 3 we were bringing into evidence,
No, after sale she can say many things. This
yes
is what
yes,
the court
but
discusses. Basically आप कुछ भी बोलेंगे.
नहीं वो ठीक है, उस स्टेटमेंट का अगर if I am bringing it into this particular document, and then it was for them to have summoned the original vendor, they could have taken steps.
Summons were issued. She chose not to appear.
नहीं, it was not issued to Salima.
कोई पार्टी है
नहीं, नहीं, वो है।
क्या समन करेगी?
नहीं, तो उसमें सम्मन गया and she does not appear to contest.
Yes.
Therefore, in their statement itself, they have said that Asarfi Lal Sahu has said in his own statement that I have asked her to give evidence, but she has not come. So what would be the impact? Impact would be that her statement, which is already there in affidavit in another statement that Asarfi Lal had knowledge about the agreement, this cannot be disputed. This is one.
You see,
This
it
is
is
one.
one thing to say whatever stand she is taking. It is another thing to say you have to show constructive notice upon the purchaser, irrespective of the stand taken by the vendor. She might have taken many stands. Right? She has not produced any documentary evidence to show that some notice was given and nothing. That is not there. She has not contested the suit. Right? Then under such circumstances, even for constructive notice also, so it is only the purchaser who is concerned. He is not
Absolutely.
concerned with whatever stand might have been
I'll
taken.
answer that also. Now here is a case where the defendant himself, he admits two things. Therefore, I read it that part,
Yes.
that he did not make any inquiry whatsoever. So whether he was required to make an inquiry or not. This is one.
Given the fact that you were in part possession of it.
Yes, this is one.
Where is the finding that you were in part possession?
I'll come to that also.
Once you come to that, I'll just come to
I'll
them.
come to that also. I'll come to that also. But Your Lordship, one more thing. That it was a case, our case was that vendor had a large piece of land
That's right.
and two portions she already sold in 73, 76, and this was, so therefore, if I was already a tenant in a portion of a large property, let us assume that I was not in possession of the property which was they had purchased.
Yes.
So then also they
You are
whether
not
they
a
were
tenant on the property. Were you tenant on the property?
on the property, but it was a large chunk of property, therefore I
You
said,
see, just a minute. There are 3 parts. 2 parts already sold to you.
yes,
No issue. Third part, what was your status with regard to the third?
third
When
part,
you were
because I
tenant?
said that that portion also would agreed to me to be transferred to me.
Were you a tenant?
Just to clarify, but there were 4 parts: A, B, C, and D. So far as A is concerned, he was tenant. That was sold to him in 73. So far as another portion, that is B, that was sold to him in 76.
Tenant.
Tenant. तो उसमें जो tenant थे वो खरीद लिए. And C and D lots, जो सलीमान vendor थी, she was in. This is our case throughout, and this
C
is
and
not
D.
their case कि C and D में ये possession हो as a tenant. They say कि A and B में हम possession में थे. 73 और 76 में हम दोनों सेट से खरीद लिए, वो दोनों जो हम टेनेंट थे जहाँ पे. This is their case.
ये 7 feet by 7 feet.
Yes.
Who is in possession?
But they say
आप बताइए ना
हाँ,
आप.
but we have-
You see who says what is not
Yes.
irrelevant. What
But-
is important is what is the finding of the
but
court.
we are in possession of this entire plot what we have purchased.
Right now you are in possession,
Yes.
but 7 feet by 7 feet. Who was it?
They were never in possession of that 7 feet by 7 feet. It is their case that they extended. जहाँ पे ये खरीदे उससे ज़्यादा ये extend कर दिए 7 feet by 7 feet, 49 square feet. ये इनका कहना है कि हम extend कर दिए इसको अपना जो कि D block का जो है जो हम खरीदे उसका एक part है छोटा सा part. ये इनका केस है. We have denied in the written statement. It is the finding कि हम लोग possession में all throughout after my purchase जब हम part payment कर दिए balance payment हम लोग possession में हैं and we are in possession.
इसको जरा कंप्लीट करिए तो
हाँ.
रीडिंग. दिस वुड बी इम्पोर्टेंट एज टू हु इज इन पोजीशन ऑफ द प्लॉट. यू सी वी आर नॉट कंसर्न विद द कंडक्ट ऑफ द वेंडर.
ठीक है, वेंडर का कंडक्ट नहीं, बट
उन्होंने क्या रिटन स्टेटमेंट फाइल किया ये भी नहीं.
ठीक है, बस बट इफ शी सेज, therefore I am
She doesn't
repeating
say
that
anywhere.
line, that if she says that the defendants were aware about the earlier agreement and then the defendant himself said that I did not make any inquiry, this is important. If he says that I did not make any inquiry because if the land was vacant would be different, but he says that I did not make any inquiry.
Need not,
then that
if it is a vacant land and if it is standing in name of
your
somebody.
lordship's query would be answered from another judgment which relevant portion I am just searching.
नहीं आप उसको बात
हाँ,
इसको
वो
इसको
हम
कंप्लीट
लिया,
करिए.
वो लिया,
ये
but
फाइंडिंग
I-
इंपॉर्टेंट है.
हाँ,
हु इज
वो
इन
हम लिया.
पोजीशन. You read para 18.
The further case of the plaintiff was that in pursuance of the agreement, a portion of the godown was extended with up to 7 feet into 7 feet north to south and east to west, and it must be deemed to be constructive notice to the defendant that this portion did not belong to the vendor when they were negotiating for sale of this suit house and the land with B.B. Sullivan. In this connection, when I look into evidence of plaintiff witnesses, I do not find that any material witnesses have been constantly stated that plaintiffs exercising their right of possession of that portion of land to the knowledge of the defendant at any point of time prior to sale of that portion in favor of the defendant appellant after the plaintiff's respondents entered into an agreement to sell the suit property with Sullivan. There is no dispute that the B.B. Sullivan, original defendant number 1, was residing in disputed house and the land prior to controversy regarding sale of suit property arose. In the defendant number 2, examined as DT.11, has denied the suggestion that he was fully aware of the prior agreement. The defendant number 2, examined as DT.11, has denied the suggestion that he was fully aware about the prior agreement. It was asserted in para 18 of the evidence that the passage of land on western side of the plot number 597 and mentioned in block T was in possession of his wife. In para 37, he has asserted that the room, door and passage were in his occupation and use. In para 46 in his cross-examination, he has asked certain questions regarding inquiry made by him in municipal record and the registration office, to which the answer was that he inquired from the sons of B.B. Sullivan about. At the same time, it is mentioned in para 2 of his evidence that the disputed land situated in holding number so and so was recorded in the name of B.B. Sullivan. So he has rightly stated that he relied upon the entries of the statement of sons of B.B. Sullivan, who were completely competent to inform him about the situation of the land in municipal record. It has been argued regarding admission of this witness in para 47 that he had not given knowledge regarding sale and purchase of this land to his in-laws. I do not find any unusual thing in it that he was going to purchase a house and land and that he was not informed his in-laws. As the answer in para 50 and 51 that he did not talk with the occupants of the plot situated on southern and northern side of the land, he has asserted that he did not consult them. It is admitted by him that he has not got the land measured In this connection, it is asserted that no reason has been assigned as to why he did not measure the land which he was going to purchase, and it showed that it was only a paper transaction. In this connection, when I look at the two sale deeds, I find that specific boundary was given in along with the area, and so it is asserted that the vendor was fully aware of the total area mentioned in these two sale deeds along with the boundaries, and it was therefore not going to make any difference for the defendant appellant that they had not measured the land at the same time. This omission was not such to show that the defendant appellant had constructive notice of the prior agreement. So far as inquiry about the person in possession is concerned, it is asserted when he purchased the land and house, B.B. Suleiman was residing in them, and he was given deliberate possession of each room from time to time, and when he used to pay part concession money. And lastly, possession of the whole house was made on 14/9/1981. This fact shows that B.B. Suleiman, who is stated to be fully aware, has filed a written statement in title suit number 69 of 1980, was in fact not inclined to give respect to the agreement of sale, and had delivered possession of major portion of the suit house and the land to which defendants prior to filing of the suit as well as during the pendency of the suit itself. It has come during the trial in evidence that B.B. Suleiman was in possession of the suit house, and so it was sufficient that Wendy's appellant had entered into negotiation for sale, and did not make any inquiry about other occupants of other portion of the house because he was not required to do so. Here, Your Lordship may kindly take note of this portion. It has come during the trial in the evidence that B.B. Suleiman was in possession of the suit house, and so it was sufficient that the appellant who have entered into negotiation for sale did not make any further inquiry about occupants of other portion of the house because he was not required to do so. In this connection, decision of our own Honorable Court reported in so and so, representing the defendant appellant, is worth mentioning here that where it has been held that by their lordship sitting in full bench that purchaser is not bound to make inquiry about previous contract from every tenant occupying a portion of the house, and inquiry from owner himself occupying a portion of the house is sufficient. In another decision reported in AIR so and so, his lordship has then held that principles of constructive notice is incorporated in explanation of section 3 of TP Act cannot be extended to a case in which the person basing his claim on the basis of prior agreement is in possession of only a small fraction of the property which he has purchased by the purchaser. As in such a case, the purchaser cannot be said to be bound to make inquiry about previous contract from plaintiff and other tenant in occupation of a portion of house. In such event, the deeming clause of illustration 11 of section 3 cannot be attracted at all, and the court cannot presume that the purchaser will have the notice of title, if any, of any person who is for the time being in actual possession of only small fraction of the property sold. The decision therefore are fully applicable in the instant case, and duty of the appellant was over as soon as the inquiry had been made from the original owner in possession of the suit property. It had been contended on behalf of the defendant respondent that in a case where the subsequent purchaser pleads want of notice, burden of proof lies on him to establish this plea. But in connection with decision reported in so and so mentioned above, it has also been held that it is well settled that to defeat the suit for specific performance of contract, burden initially lies on the subsequent purchaser to prove want of notice. But this burden is somewhat lying. Mere denial may suffice, shifting the burden on to prove that the purchaser has knowledge about this prior contract before he purchased the property. In the instant case, I find from material available on record that the question of constructive notice to the defendant appellant of prior agreement was not substantiated by cogent evidence, and his plea that because the owner was in possession of disputed property, he relied upon her and her son, suit property belonged to them. It is admitted in evidence that he was fully aware that the plaintiff respondent has purchased the northern and southern portion of this disputed land and is in possession So that is the matter duty burden of making more inquiry regarding their possession was not required.
You read further para 20.
Skip करें पर
नहीं para 20 पढ़ी.
It has been further been contended that though the sale deed was taken on 25/1/1980, it has been admitted and also supported by the documentary evidence that the possession of the house was not made over to the dependent appellant there and there. That being so, the contract for sale of for which the sale deed was registered was in fact completed during the pendency of the suit when the possession is said to be completely handed over to the purchaser as claimed, and so it is hit by principle of dispendence under section 52. In this connection, it must be question. I'm skipping. Mentioned that in such a case, a transfer of immovable property, registration of the document, and delivery of possession document to the purchaser is sufficient compliance of the sale, and the sale is complete as soon as the document is delivered. And even if there is a stipulation that a part of concession money is to be paid later on, will not cause any hindrance in passing title to the purchaser. Here I'll pause here. Here it mentioned that if the sale deed itself mentioned that part concession amount would be paid later on, then this finding could have been made, not otherwise. If the sale deed itself mentioned that entire concession amount has been paid, then it would the subsequent payment of
The
concession.
sale deed mentioned that the entire consideration amount has been paid.
Because that is the content of the deed.
You refer it from the impugned judgment. We can't just go into the documents to such an extent.
It has been held in 1971 Odisha that passing of title is according to intention of parties and does not depend on payment of concession. In the instant case, title passed to the vendee, the defendant appellant on the date of registration of the document and handing it over, and delivery of possession of the rooms was only with the mutual consent to the parties, not affecting the title of purchaser. To sum up, the plea of either actual or constructive notice of the previous agreement could not therefore be imputed to the defendant appellant, as the defendant appellant was not proved to have actual or constructive notice of earlier agreement, and title through registered deed was transferred to them through a legal document. The finding of the learned lower court on this point is cannot be sustained. The decree was not enforceable against the heirs of the defendant number 1, as they had no right, title, and interest on the suit property. The plea of readiness and willingness on the part of the plaintiff respondent to perform his part of the contract had become immaterial, as the vendor had transferred her property much before the suit and instituted and had no right, title, and interest on the suit property. Not only that, no consequential relief or refund of the concession money was sought for, and no decree against the defendant appellant or so and so defendant respondent second party would be passed. The learned lower court in his judgment has obeyed as observed as to the suit property mentioned in block E, that is passage, no decision could be given as the matter was sub judice before the lower court in title suit number 69 of 1980, and so he did not decide the controversy. In my opinion, his finding was not correct. The learned court should have decided the controversy relating to the land situated on the western side of the described as passage, because in title suit 69 of 1980, relief was for injunction, which was a different matter, and in the present suit, question was otherwise. As I have found that the defendant appellant have succeeded in their claim that they were protected under proviso to exception 19B of the specific relief act, so the suit should not have been decreed against them, nor it would have been decreed against the non-contesting defendant, as they had transferred their title to the defendant appellant prior to institution of the suit, and also because no relief or refund of
You see, you were not in possession of any portion of the suit.
this finding is bad. I'll show it from
But
subsequent.
that finding we cannot enter into. We will not enter into that finding.
Because the court does not say that I am not in possession of the property, because the trial court said that this
Is
finding
there
was
any
there.
finding of the trial court that you were in possession of the property?
Part with regard to 7 feet by 7 feet.
Is there any finding of the
No,
learned
that-
trial court? Please show us that finding, because
No,
there is
I'll
no
come.
clear finding by the appellate court on this. Show me that finding that you were in part possession of the property. Part possession will have a lot of bearing in the matter. Because the appellate court says that if you are, there was no need of any inquiry. There was no need of any inquiry over and above the vendor and their son. This is
Yes,
the finding
but
of the
it
learned appellate.
also says that even if there is a part, only they are in possession of part, then that would also not be required. That is the finding of the appellate. That they were not required to find out other persons who are in possession. This is
So
the
therefore, we want to see, has the learned trial court given any finding that you were in possession of the property?
in part performance also. In the meantime, Your Lordship, may I pray one thing? In the meantime, the net senior counsel, he will be arguing on behalf of 1A. So,
1A.
so I'll show that finding also. I'll
ठीक है,
just-
आप बताइए आपको क्या बोलना है सर?
and
रिपीट कुछ मत करिएगा.
हाँ, in
जितना
the
बहस हो
meantime,
गया है
I'll-
उसको रिपीट मत
in
करिएगा.
the
उसके
meantime,
अलावा
I'll
आपको क्या बोलना है?
just place 2 judgments after.
हाँ, ठीक है. Who is in possession, sir?
Well, in fact, 7 feet into 7 feet, there are evidences that it has been constructed at my cost, and it is in my possession. Now, let me.
Just a moment.
I just want to place the London Appellate Court judgment where she has held that the defendant is protected under section 19 of the Specific Relief Act. I pray, my Lord, that I may be
हाँ बताइए 17
Madam.
by 7.
Page 40 of the learned appellate court judgment, the learned appellate court has said that as I have found that the defendant appellant has succeeded in their claim that they were protected under the provision of exception contained in section 19B of the Specific Relief Act, the suit could
पैरा
not have
नंबर
been
कौन सा पैरा पढ़े रहे सर?
by page 40 of the appellate court judgment.
Page 40.
G.
It has पैरा number 18. Appellate court judgment
हाँ.
page 40. Just it has पैरा number.
पैरा 21 है.
आपका पैरा नहीं है.
पैरा appellate court judgment.
आपका appellate court judgment के पैरा 40 में पैरा 18 है. मेरे पास जो.
अच्छा ठीक है. The learned lower court in the judgment जिससे शुरू हो रहा है.
But this is para 21.
वही तो बोल रहे हैं.
तो आप पैरा 18
नहीं पैरा 21 मान.
पैरा 21 है हमारे
The
इसमें.
learned lower court.
एक सेकंड पैरा 21 जो है
In fact हम तो certified copy ही आपको
हमारे
मिला है.
पैरा पेज 47 में पेज 47 में है पैरा 21 जो मेरे पास
मेरे
है.
तो 41 में खत्म हो जाता है.
नहीं हमारे पास 47 48 पेजेस हैं.
In fact हम लोग को certified copy ही लेना पड़ा है. इसी honorable court से हम लोगों ने लिया है. And yesterday I was briefed. And in fact para 21 हम place कर रहे हैं.
पढ़िए
In the middle of this paragraph,
पूरा पढ़िए पैरा
the
21
learned lower court in his judgment had observed that as the suit property mentioned in block E, that is passage, no decision could be given as the matter was sub judice before the lower court in title suit number 69 of 80, and so he did not decide the controversy. In my opinion, his finding was not correct. The learned lower court should have decided the controversy relating to land situated on the western side, that is the passage manor, describing as passage. Because in title suit 69 of 80, relief was for injunction, which was a different matter, and the present suit was otherwise. As I have found that the defendant appellant have succeeded in their claim that they were protected under provision of exception contained in section 19B of a Specific Relief Act, the suit could not have been decided against them, nor it would have decreed against non-contesting defendants, as they had transferred their title to the defendant appellant prior to institution of the suit, and also because no relief for return of money was as an alternative relief was sought for. Now, Lord, I humbly submit that the finding of the court that the appellant have succeeded in defendant appellant have succeeded in their claim that they were protected under provision of exception contained in section 19B of the Specific Relief Act. I humbly submit, I may be permitted to read section 19 of the Specific Relief Act. Relief against parties and persons claiming under them by subsequent title, except as otherwise provided by this chapter, the specific performance of contract may be enforced against either party thereto, which is not in connection. B. Any other person claiming under him, that is the vendor, by a title arising subsequently to the contract, that is the agreement, my lord, except a transferee for value who has paid his money in good faith and without notice of the original contract. Now, my lord, the person must be a transferee to get the protection of this provision. He must have paid the money and in good faith. If these three things are there and without notice to the original contract, then my lord he will get the protection. Now number one, my lord, a person would be a transferee only after he has paid the money. My lord, the paid Madras High Court, Honorable Madras High Court says that half payment, part payment is no payment. Full payment, there must be a full payment, only then this protection will be available.
That is not the substantial question.
In fact, my lord, I have made it a prayer, my lord.
सर अभी 2 घंटा से हम सुन रहे हैं, अभी
ठीक
आप
है।
एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ की कोई बात मत
एकदम ठीक
करिए।
है।
जितना सब्सटेंशियल क्वेश्चन ऑफ लॉ है बस उतना ही पर डिसाइड करेंगे।
वो भी ठीक है।
कंस्ट्रक्टिव
एक
नोटिस
चीज
दिखा
हम बोल
दीजिए
रहे
एंड
हैं,
यू हैव द
for
केस।
doing, my lord, consignable justice according to law.
सर सेकंड अपील में कंसाइनेबल जस्टिस नहीं होता है, सब्सटेंशियल क्वेश्चन ऑफ लॉ को आंसर करना होता है एंड दैट हैज टू बी आंसर्ड इन अकॉर्डेंस विद लॉ एंड स्ट्रिक्टली इन अकॉर्डेंस।
My lord, justice according to the law होना ही चाहिए।
सब्सटेंशियल क्वेश्चन ऑफ लॉ
I humbly pray, my lord, that this honorable court will not shut his eyes from the provisions of law and its application.
I only know one thing, for substantial question of law I have to answer only that, not even a word more than that.
Even if that is there, my lord, the evidences have come from the
Payment हुआ
plaintiff.
नहीं हुआ,
Evidences
whether that
have-
will amount to constructive notice,
ठीक है,
We are not
constructive
concerned.
notice तो था ही। जब plaintiff has
आप
come in the,
कंस्ट्रक्टिव नोटिस दिखा दीजिए और कहानी
the
खत्म।
plaintiff has come to say in as a plaintiff witness number 19, other witnesses 4, 11, 12 and 19, these 4 persons have deposed in the court that they had the knowledge, and this defendant Asharfi Lal,
सर
My-
जजमेंट से दिखाइए
my-
which portion, sir just a moment, even the appreciation of evidence by the first appellate court is full and final and it is binding.
yes,
Unless you show that this particular evidence, this particular appreciation of evidence is perverse,
my
right?
it is perverse.
Show me
Because
whose evidence is perverse
Bas-
and by virtue of which paragraph of the evidence it is perverse.
Well, the finding of the appellate court that the
Sir,
defendant would get
paragraph
benefit.
दिखाइए, paragraph
नहीं, judgment में ही बोल रहे हैं कि the defendant would get benefit of section 19B. In my humble submission, that is perverse. He will not get benefit of 19B because he has not paid the amount and therefore he is not a transferee.
that is
If-
not the question of law.
My lord, the finding of the court, the finding of the appellate court is perverse. This is my humble submission, my lord.
सर
This
एक
honorable-
चीज को हम बार बार नहीं रिपीट कर सकते हैं। आई विल नॉट डाइग्रेस फ्रॉम द क्वेश्चन ऑफ लॉ। जो क्वेश्चन ऑफ लॉ है उसको एक बार आप पढ़ लीजिए और उसको समझ लीजिए और आप हमको समझा दीजिए कि आई कैन मूव टू दिस इफेक्ट। रीड द क्वेश्चन ऑफ लॉ।
My lord, if I have understood it, in my lord's order dated 5th of August this year, 2025, my lord have concised the previous orders. The question of law, substantial question of law, which was framed on 21st of November 2000, in my lord's order number 22, 5th August 2025, the question of law is whether the Court of Appeal below erred in law in holding that defendant 2 and 3 had neither actual or constructive notice of the agreement for sale in favor of the plaintiff. Now, my lord, this will be available to the defendant 2 and 3 only if he is protected under section 19B of the Specific Relief Act. And if I remember, my lords, in the very beginning asked the land council, my learned brother arguing for the other appellates, that 19B will come in the way. It will be required to be discussed, my lord, and decided whether the defendant was protected under section 19B, whether he was a transferee. In fact, my lord, yesterday in the daytime I was asked to argue this case, and a few humble substantial questions of law I could make out. If my lord kindly looks into it only.
Sir, you confine your arguments to the substantial question of law already framed.
Then, my lord, this actual or constructive notice of agreement or sale in favor of the plaintiff. This will be available only if he comes up under the protection of 19B, otherwise not. Then this substantial question of law frame will, my lord will like to answer it in the affirmative. And the learned appellate court also has held that the agreement was not a mere agreement, it was a contract, and it was a genuine contract. These findings are already there in favor of the plaintiff by the appellate court also, both the courts.
What is the date of Exhibit B and VY1?
Exhibit B, my lord.
Exhibit B and VY1.
I will take only 1 or 2 minutes.
And 81 का ये.
And B by 1 is 7481.
किसका पैसा बाकी है?
So
by 3 is
5,000 किसका बाकी है?
parts of the second sale deed notice.
Perhaps it will
B by 1.
B, sale deed is A and A by 1. Page 14. Page 14 of the
किसका 5,000 बाकी है?
Can we check the NCR notes just to verify the exhibit B?
Exhibit B is a receipt for payment executed by B.B. Salima in favor of Asarfila South, dated 21/2/80. Exhibit B by 1 is a receipt dated 7/4/81. B2 is a receipt dated 11/4/81. This is all I am reading from the trial court judgment, page 14.
What is B2?
B2 is below the receipt dated 11/4/81. These are dates below. B3 is also there. If my lord asks, I can give
These are the payment dates.
payment dates.
Yes.
Payment dates. So at least, my lord, by the sale deed, he was not protected under section 19B, my lord. The defendant was not protected. And if 19B is not there, then 19 will come to the rescue of the plaintiff. If there is a previous contract, in violation of that contract, any sale deed executed subsequently will be null and void.
किसका 5,000 रुपए बाकी?
But 5,000 किसी का बाकी नहीं हुआ. Taken instructions. I will just tally it from the exhibits also.
तो लिखा हुआ है, लिखा हुआ है ना.
ये तो सर ये NCR में निकाल आते हैं.
दिखाई चलो WC. पुराना किसका WC? Exhibit 14.
But I have got the certified copies of the evidences also.
आप देख के बताएंगे
My lord,
किस डेट किस सेल डीड में कौन सा एग्जिबिट कब हुआ? सही.
Perhaps at page 10 of the appellate court judgment, there is a reference. I may be permitted to read.
Yes.
Sub-Registrar Hazaribagh and balance amount which had already been paid subsequently. Last but the 4 lines.
Yes.
Under valid receipt and remaining amount of 5,000 due to defendant number 3. Defendant number 3 is Chandrakanta Devi, who happens to be the wife of defendant number 2. So it is in regard to the second sale deed, which is A by 2. Exhibit A by 2.
Now you tell us that the trial court has taken some view on account of non-payment of full consideration amount,
Yes.
right? Has the learned appellate court considered it?
No.
What is the consequence of non-payment of full
Short payment.
consideration amount?
Yes. No. The appellate court has not taken.
Where is that finding of the learned trial court with regard to part payment of consideration amount?
But the entire payment of 45,000 have been paid.
When?
Yes, but these are all exhibits.
Tell us the
Yes.
dates. You
Yes.
have taken a specific stand that 5,000 you are still ready to pay in your written statement.
But in my written statement, which was filed in the suit, but during pendency.
That is pendency का कहानी छोड़ दीजिए ना. The list begins
Yes, the list begins.
on the day you had filed your written statement. By that time that amount was not paid. उसके बाद आप किसी को अपना आसमान दे दीजिए, उससे क्या लेना देना.
बट हम तो उन्हीं को दिए जिससे लिए, उन्हीं का रसीद है और सारा डॉक्यूमेंट
और वो
एग्जीक्यूटेड
गायब है.
नहीं, बट हम तो उल्टा इनका कंडक्ट उस पे दिखेगा कि हाँ जिससे हम खरीदे उसको ही मैनिपुलेट करके बोल दिए कि हाँ 40,000 में इनका एग्रीमेंट है.
आप हमको बस इतना बता दीजिए. Trial court ने has taken a view
Yes,
in connection with your in connection with the non-payment of the full consideration amount.
yes.
वो व्यू आप बताइए कहाँ है और उसको एपेलेट कोर्ट ने कैसे डील किया. और अगर एपेलेट कोर्ट ने नहीं डील किया है तो इट्स अ मैटर ऑफ कंसर्न, और डील किया है तो कहानी खत्म, फिर तो कोई बात ही नहीं.
हम देख लो once they conclude, I will just-
The consideration with regard to the payment is at internal running page 28 of the trial court judgment.
There is another strong circumstance.
Absolutely. There is another strong circumstance to support the case of the plaintiff that the defendant number 2 and 3 has not made full payment of consideration at the time of execution of the sale. On the date of execution of the sale, only rupees 20,000, 10,000 for each sale were paid, and they were not put in possession over the land on the day it appears. At the time of execution of the sale, Bibi Salima was in possession of the land and hence and house, and according to the case of the defendant number 2 and 3, have got possession after 25 days. One koha of the house. When they made payments of the remaining consideration amount at different dates, they were put in possession of the entire house.
आगे पढ़िए. It is
also a strong circumstance in favor of the plaintiff. The sale deed obtained by defendant number 2 and 3 has not been obtained after due payment of consideration. This is the fact. Subsequent page, my lord, the second paragraph. After considering the case of the parties and material available on record, I find that the defendant number 2 and 3 had knowledge about agreement between the plaintiff and defendant number 1. Thereafter, my lord, natural justice and equity has been dealt with.
And where is the discussion of the learned first appellate court on this?
That starts at page 29. Para 60.
No, with regard to part payment of consideration.
No, there is no consideration. There is only consideration with regard to prior notice and constructive notice.
Because that circumstance has been considered by the learned trial court, that there was part payment with regard to the consideration amount.
Although the learned appellate court considers section 19 of the specific relief act, but the portion which saves the specific performance has not been dealt with.
And with regard to 7 feet by 7 feet, is there any finding?
Factum is there, my lord, that plaintiff was in possession of 7 feet into 7.
कहाँ से finding? Finding दिखाइए. Show me some
नहीं,
finding.
वो नहीं है.
नहीं है तो फिर क्या करेंगे? यहाँ तो नहीं दे पाएंगे ना.
The case of the appellant herein is that they are in possession.
Everybody's,
defendant's
both
claim-
the parties' cases that they are in possession.
Peter Commissioner report is there, the possession, and there is some board set up by the appellants herein.
Leader Commissioner's report has been rejected.
Trial court has relied for document of payment.
My WS, not your lordship and movement, my WS is 7981, 7th of September 81, and the last payment of balance 5,000, which your lordship mentions in the written statement, is on 14/9/81, exhibit B by 4. That is after filing of the written statement, and that is exhibit B by 4. I have checked from the records, but entire 45,000 was paid.
After the written statement.
After the written statement,
The
balance
WS was filed on
7981. And
81.
the
And
B by 4, that is last 5,000 is 14,981.
who paid to whom?
But it was paid to the vendor Salimal, but I will just check from the record.
It is in relation to which sale deed?
But सेल डीड के बारे में लिखा हो, क्योंकि हर सेल डीड में लिखा हो कि पहले सेल डीड में 20,000 रुपया मिला, उसके बाद बैलेंस जो पेमेंट होते गया है पहले
10,000 मिला।
हाँ सर 20 में से 10 मिला, उसका जो पेमेंट होते
ये जो
गया
पेमेंट है 5,000 रुपए, ये किसकी तरफ से? मतलब ये कौन सा सेल डीड से रिलेटेड है?
ये हम चेक कर लेते हैं।
आप चेक
हम
करिए,
check
बी एंड बी बाई 1
हम check
दिखाइए
करें।
कौन सा सेल डीड से?
हम चेक करते हैं। हाँ
And both of them are husband and wife.
Yes, husband. हाँ।
Exhibit B दिखाइए। वो लेके गए। इनका रिटन स्टेटमेंट लिखा है, ये है क्या? नहीं, ये है 43 डिफरेंट स्टेटमेंट।
But exhibit B by 4 note, the last payment is made by note Chandrakanta Devi in favor of the vendor B.V. Saliman, and this is note in relation to exhibit A by 1. दोनों सेल का डेट एक ही है, लेकिन A by 1 बिकॉज जो उनका सेल है उसी का पेमेंट किया जाए।
So this one that
उनका-
immediately after this one.
जस्ट उनका सेल डीड का वैल्यू कितना था? सेल डीड का वैल्यू
25,000।
दिस वाज फॉर 25,000 वाला सेल डीड, ठीक है?
Yes.
और ये 20,000 वाला कब?
नहीं,
शुरू में तो
10,000
10,000 पेमेंट किए थे।
शुरू में 10,000
हाँ,
पेमेंट किए,
उसके बाद
हाँ, इसके बाद
बताइए।
इसके बाद नोट एग्जिबिट बी है,
एक सेकंड, एग्जिबिट ए का कंसिडरेशन अमाउंट था 20,000,
20,000
एग्जिबिट बी का कंसिडरेशन
नहीं,
अमाउंट
A by 1,
सॉरी
A by 1,
ए बाय 1 का कंसिडरेशन अमाउंट वाज 25,000।
हाँ
इसका लास्ट पेमेंट 5,000 रुपए,
हाँ
5,000
5,000
5,000
14,981
14,981 ड्यूरिंग पेंडेंसी ऑफ सूट,
Yes.
पेंडेंसी ऑफ सूट, राइट?
Yes.
ओके, और इसका लास्ट पेमेंट एग्जिबिट
बट इसमें 4 पेमेंट है, 1 2 3 4 5 पेमेंट है नोट 5,000 ईच का।
A1 से,
नहीं, A और A by 1 नोट सेल डीड हो गया।
हाँ
B सीरीज जो है B1 से B by 4
हाँ।
वो 5,000 का 5 पेमेंट्स है।
एग्जिबिट ए का रिमेनिंग 10,000 कब पेमेंट हुआ? अशरफी लाल ने कब पेमेंट किया?
अच्छा, ठीक।
अशरफी लाल नाम है ना?
हाँ,
बताइए।
एक है नोट 21/2/1980, this
21
is
to
exhibit
1980, this is 10,000,
5,000।
this is 5,000।
Yes.
उसके बाद
It mentions कि 20,000 में बात हुआ,
हम्म,
10,000 पेमेंट हुआ,
हाँ।
बैलेंस 5,000 दिए,
हाँ,
एंड नेक्स्ट इज नोट,
बैलेंस नहीं, उसके बाद भी तो 5,000
हाँ
रुपए बचे।
मतलब उस बैलेंस में से 10 में से 5 दिए,
5,000 बाकी का पेमेंट,
हाँ, और 7,481
7,481 में रिमेनिंग 5,000
remaining
रुपए पेमेंट
हाँ,
किया।
this is exhibit B by 1,
एग्जिबिट बी बाई
B by 1,
ठीक है, लेट अस सी, दिस इज बी बाई 1
हाँ,
and this is exhibit B,
Yes.
and this is relating to Exhibit A.
A.
Okay.
Yes.
तो सेल डीड का क्या डेट है? सॉरी.
Sale deed and notes. This is 25/1/80.
25/1/80
Both sale deed same date.
का डेट है. ठीक है. इसमें 10,000 रुपीज पेमेंट हुआ.
हाँ.
ठीक है. ऑलराइट. उसके बाद ये दिस 7/4 आपने WS कब फाइल किया?
और WS फाइल किया 7981.
7981.
हाँ.
ओके. पुराना वाला सूट में वैल्यू पार्टी
Sorry, पुराने वाले.
60 में वैल्यू पार्टी.
Yes, ma'am. I was
यू आर पार्टी.
Yes.
उसमें उनका रिटन स्टेटमेंट फाइल हो गया था बाय दैट टाइम. यस और नो?
This do not have to check.
व्हाट डू यू हैव टू चेक? व्हाट डू यू हैव टू चेक अबाउट इट? 1960 का सूट है ना? 1980 का सूट है.
हाँ.
आपके इसमें पेमेंट करने के पहले तो वो फाइल हो चुका था. करेक्ट? राइट? एंड व्हेन वर यू पुट इन पोजीशन अकॉर्डिंग टू यू?
Sir, no, there is a date mentioned in the order 7 after payment of the entire. Your Lordship, I'll just give the date.
Suit was already filed, but your lordship. In 83 probably she had filed written statement. That fact are not.
We'll check these facts. These facts are relevant.
14/9/81 notes on the last date of payment.
14/9/81 you got possession.
उससे नोट जैसे जैसे हम लोग दिस इज आवर केस कि जैसे जैसे हम लोग पेमेंट करते जा रहे थे वो पोजीशन हैंडओवर करते जा रहे एंड अल्टीमेटली द होल हाउस वाज हैंडेड ओवर ऑन 14/9/81. दैट इज द लास्ट डेट ऑफ पेमेंट. Exhibit B/4.
It's 1980.
Yes.
It's typo.
It had already been filed. The WS had been filed on 19/7/19.
Page 30 of the chart.
नहीं ऐसे नहीं.
19/7/80
1980.
in the previous suit.
In the previous one. Exhibit 14 is a written statement filed by defendant number 1 BB Salima and TS 69 of 80 in the court of Municipal.
Who was the plaintiff in that case?
I was the plaintiff. Appellate was the plaintiff in 69 of 1980.
Were the vendors party?
Yes. Vendors.
Vendors were party in the previous suit?
Yes, ma'am. Because that was for the injunction,
Injunction.
grant of injunction only, confining to grant of injunction only.
So
Not
where
for
do you say that the vendors were party?
If it is heard tomorrow, will it suit you, Lordship?
No, it will not suit.
No, but it's in
ये सारी चीजें
1980
जो आपसे पूछ रहे हैं ना, ये आपके टिप्स में होना चाहिए.
But in 1980
These sequences should have been at your tips. जो आपको इतना क्वेरी करना पड़ा. When you are talking about constructive notice, these are absolutely basic details.
Yes, ma'am.
But so far as suit of 80 is concerned, injunction suit, my written statement note is not exhibited by either of the parties. I've checked the exhibit list, not there is no. It is
Your
only
written statement is immaterial.
no.
But the moment they file their written statement, it's within your knowledge.
Sorry, they filed a claim. They've instituted. I have not instituted the suit.
Like they.
Why you will find it?
That's right.
Yes.
You were co-defendant in the suit.
Yes, I was co-defendant in the suit.
And the moment the defendant number 1 files a written statement in the suit,
Yes.
it comes to your notice immediately.
But therefore,
Does it or
there
it
has to
doesn't?
be a case pleaded by them that by way of this, because they were summoned, they were appearing through an advocate there, and therefore by filing of the written statement in that 80 suit, they have knowledge. This was never the case. Your Lordship may see the plaint itself. Was there the case treated in the plaint? But their only case is that they were in possession in 7 feet into 7 feet. This is the case, and on that they are pleading about constructive notice. Actual notice, there is no document to show. Constructive notice, their only case and pleading is that 7 feet into 7 feet. Your Lordship may see the trial court finding notes on that. What the trial court records, because decision notes, affirmance, I would say, so far as this possession is concerned, 7 feet into 7 feet finding. The Lordship may kindly take note of trial court judgment, page 28.
Is there any material on record to show that on 7/4/81, you see there are two sale deeds. There is no doubt with regard to one of them that there is a subsequent payment. So far as the other sale deed is concerned, there is a payment prior to filing of the written statement. That is on 7/4/1981. That is the last date of payment of ₹5,000. Is there any material on record to show that they had knowledge about the agreement prior to 7/4/81?
Because of the written statement that was filed by the co-defendant, that means vendor, in the year 1980 itself.
I just want
So
to know
whatever-
were they party in that proceeding?
Yes, they themselves say that they were party. It was a case of injunction where they were also party. All the three of us were party. So if all the three of us were parties, in that suit, when despite execution of the deed of sale, if the vendor herself appears and says that this or whatever has been stated, so payments made after that, can it be said to be bona fide under 19(1)(b) and without knowledge? Because the moment she filed, post that date, whatever payment was made, absolutely that has to be. Similarly, Your Lordship, I stand corrected that whatever statement she had made in my favor also after transferring, had it been a case where she had absolutely transferred the property, the matter would have been different. But here, their own case is that they have not even been put in possession entirely, only a part of the portion was given. Therefore,
लिखिए इसको रिफ्रेम करेंगे सब्सटैंशियल क्वेश्चन. इट इज रिक्वायर्ड टू बी रिफ्रेम. उसको बिना नहीं डिसाइड, क्योंकि ये सिर्फ कंस्ट्रक्टिव नोटिस पर नहीं डिसाइड हो सकता. 19B पर हम लोग को ध्यान ही पड़ेगा.
Can I pray?
19B पे बिना जाए आप हमको बताइए. How do you just tell us?
No, Lord, can I pray one thing? Your Lordship is formulating not question of
You
law.
will get time. Naturally,
No, I will
right?
get time definitely, Lord. I am also praying that your Lordship may also formulate issue of readiness and willingness.
I will.
Yes.
Readiness and willingness.
Yes.
There is a finding against you. You just use the substantiate. There is a finding against you
No,
that
Lord.
there is readiness and willingness.
Yes, your Lordship may formulate it.
Why should we
Yes.
formulate
But this,
a point when there is a clear finding of readiness and willingness?
there is no issue by any court. Your Lordship may kindly see
Need
the
not,
issues.
no, we are not
and-
going to think that. You see, it is not a matter of bargain.
No, it is not a matter of
This,
bargain. But I am saying
this particular proposition of law that on the date when this substantial consideration amount has been paid after knowledge, so you will have your right to say that, right, after knowledge about the fact that there is already an agreement for sale, whether the payment can be said to be in good faith, and whether you will be entitled to protection under section 19B.
But I will
This
answer,
is a substantial.
No, I will answer that. Not, but your lordship will also take into consideration. Not in a suit for specific performance. But I argued in the last bit also. Not the basic requirement is not he has to plead and he has to prove that. Not where is the issue by any of the courts below about readiness and willingness, and not the appellate court your lordship has seen. The appellate court only not in.
You see, the matter was remanded, certain issues were framed,
Yes.
right?
Yes.
And then that issue was not framed.
Well, once it was an open remand.
It is not an open remand.
No, it can't be a closed remand because the question of law was not
The
formulated.
point of determination was, you said, just see, the point of determination, the 3 points were already formulated at the stage of remand.
No, not at the stage of remand,
Yes.
but the court only says it remanded the matter back to decide afresh. That is under Order 41 Rule 23, not 25 rules. 25 is formulating questions and then remanding to decide that questions.
Your Lordship, only 2 lines I'll say. Your Lordship may kindly see Order 14, Order 13 Rule, 14 Rule 1. What is the issue?
Not what the court
It
says,
says
appellate court about
very
readiness and
clearly
willingness,
that
your lordship may
affirm by
kindly.
one side
No, let me just
and
read
I-
this. What the court says about readiness and willingness is that the decree not enforceable against the heirs of defendant number 1 as they had no right, title and interest in the suit property. The plea of readiness and willingness on part of the plaintiff respondent to perform his part of the contract has become immaterial as the vendor had transferred her property much before the suit has been instituted and so had no right, title, interest in the suit property. This is only the finding. Where is it against me? Notes? It is not against me. The court says that it has become immaterial. Therefore, I was saying, once your lordship is formulating your question of law, your lordship may also formulate this question. Second last page of the appellate court judgment.
Just
Your Lordship,
Just before
last
para
day,
21.
My submission, Your Lordship had recorded that they had not denied my statement with regard to readiness and
This is what I am looking for.
yes.
Where is your
And
statement
in my
regarding-
para 7,
Para
I had stated and it was replied by them, and this particular fact was not denied by them. So how issue would be framed? If no issue can be framed, then there's no
So it
question.
is the burden of the plaintiff to prove this.
It would not go into
It is
a
the
question
burden.
which is not.
Let us
even
assume
clear.
that if someone has not filed a written statement, the suit is ex parte. The court will not presume it. It is the burden of the plaintiff to discharge it. बोलो वो appellate court का para 21 का ठीक है
Para 7 I have stated that the plaintiff has always been and is still ready and willing specifically to perform the agreement on his part of which the defendant has or had notice, and this has been replied by them in para 7 of their WS again.
No knowledge of any notice.
Yes, that is all. And 7 and 8
But
have been replied together.
even
No
if I
specific
assume, Lord,
denial of this fact.
I say, Lord, no knowledge of it, but my written statement, but I being a purchaser cannot say, take a plea that he was not ready and willing. Therefore, Lord, it is the court's duty, Lord, and it is the plaintiff's duty to prove this fact in a suit for specific performance. I will cite Lord judgments on that. Therefore, I was saying, Lord, your Lordship, because 16C, your Lordship will see. C.
Okay. Please take it. During the course of arguments, it transpired that there are two sale deeds involved in this present case. Exhibit A and A by 1. Exhibit A was in favor of Ashrafi Lal Sabu, ये है ना नाम?
हाँ,
Exhibit A/1 was in favor of
Chandrakanta Devi.
Chandrakanta Devi.
Husband and wife.
Both were husband and wife, and the consideration amount was rupees 20,000 and 25,000 respectively. The last payment of rupees 5,000 in connection with Exhibit A/1 by Chandrakanta Devi was made on 14/9/81, which was after the filing of the written statement in this case. The written statement was filed on 7/9/1981. The exhibit B/4 is relating to the last payment of rupees 5,000. So far as Exhibit A is concerned, the last payment in this connection is dated 7/4/81, which is Exhibit B/1, and this payment was made prior to filing of the written statement. However, there is also a written statement placed on record in connection with the previous suit, that is Exhibit 14, which was filed on 19/7/1980 in title suit number
69 of
1980.
69 of 1980, in which all the parties in the present case were also parties, and the suit was relating to
injunction.
injunction. It has been argued by the learned counsels appearing on behalf of the appellants that for getting the benefit of section 19 within bracket B of Specific Relief Act, certain preconditions are required to be satisfied. Those are that a person claiming that the subsequent purchaser or any person claiming under him ought to have purchased the property for value and has paid his money in good faith, and further without notice of the original contract. The learned counsel has submitted that the payment of consideration, part payment of consideration amount, at least part payment of consideration amount in connection with these two sale deeds are not in good faith in view of the fact that part payment of rupees 5,000 in connection with Exhibit A was made on 7/4/81, which was after the filing of the written statement by the vendor on 19/7/1980 in the previous suit. And so far as the part payment in connection with the Exhibit A/1 is concerned, the same was done after filing of the written statement in the present suit. The payment was done on 7/4/81. The payment was done on 14/9/81 within bracket Exhibit B/4, and written statement in the present suit was filed on 7/9/81. The learned counsels have submitted that the learned first appellate court has wrongly come to a finding that the defendant number 2 and 3 were entitled to benefit under section 19 within bracket B of the Specific Relief Act. They have submitted that the substantial question of law is only relating to previous notice of the agreement of sale, but there is a substantial question of law involved in this case as to whether the payment of money in consideration with the sale deeds was in good faith or not. आपको इसमें कुछ dispute है इस submission में?
हमको इस submission
Just a
में
moment. This order has been dictated in open court and the learned counsel for the respondents has also does not dispute this aspect of the matter which has been brought on record. In view of the aforesaid facts and circumstances, this court is of the view that an additional substantial question of law arises in this case as to whether the money paid, whether in the present case the money paid during the pendency of the suit in connection with Exhibit A by 1 and the money paid with respect to Exhibit A after the filing of the written statement in the previous suit would amount to payment in good faith, so as to नहीं इसको ऐसे करिए so as to entitle the defendant number 2 and 3 for the benefit of section 19 within bracket B of the specific relief act. The two substantial question of law which has been framed earlier and the present one would essentially deal with the basic requirements of section 19 within bracket B of the specific relief act. दोनों ingredient
transferee is required.
हाँ दोनों ingredient हो गया ना दोनों ingredient
And your lordship,
both the ingredients of section 19B, one is payment of money in good faith and without notice to the original.
Your lordship may also formulate not readiness and willingness issue, because that will also be very relevant for deciding this.
The learned counsel for the respondent has also submitted that the readiness and willingness to perform the part of the contract is also an essential ingredient under section 16(1)(c) of the Specific Relief Act 1963. He has submitted that no issue was framed in that connection and consequently even if the aforesaid issue regarding aforesaid questions of law regarding 19B is decided in favor of the appellant, then also in absence of this basic ingredient, the appellants would not be entitled for specific performance of contract. ये करना
मेरा भी submission
The
that he
learned-
has not denied, and the issue is framed in terms of Order 14, which specifically says that matter averred stated by one party and denied by another. So that
The
will be the
learned
issue.
counsel for the
But then-
appellant has submitted that there was a specific statement made in paragraph 7 of the plaint that the plaintiffs were ready and willing to perform their part of contract and there was no specific denial on the part of the respondents, on the part of the defendants with regard to readiness and willingness to perform their part of contract.
Yes.
And therefore, this substantial question of law may not arise for consideration in this case.
But your lordship may also
Is there
record
any
my
finding with readiness and willingness?
only that not just para 21 to
Appellate court
The
says
appellate court finding is
procedure
there
करते
that
नहीं.
no issue was framed.
No issue was framed. Otherwise, there is any observation.
yes
Yes.
appellate
Yes.
court but para 21 just to
करते हैं. Page 39.
मैच नहीं करेगा सर para 21 का ठीक
The plea of readiness and willingness on the part of the plaintiff respondent to perform his part of contract has become immaterial. This is the court saying.
Para number?
Para
21 के ठीक
page
ऊपर.
39 देखा जाए.
paragraph 21 के ठीक ऊपर
Yes.
Para
Just
21 के ठीक ऊपर नहीं है.
हाँ.
Appellate court judgment.
हाँ appellate
Appellate.
court
टाइप रिटन है appellate
But appellate court judgment में para 21 के नोट ठीक ऊपर यहाँ देखा जाए.
Four, five
The
lines.
plea of readiness and willingness. हम पढ़ देते हैं.
Appellate-
The plea of readiness and willingness on
अच्छा,
part of the
okay.
plaintiff.
In response, the learned counsel for the respondents has submitted that the plea that the learned appellate court has not entered into the plea of readiness and willingness on the part of the plaintiff to perform his part of the contract by observing that it has become immaterial as the vendor had transferred his property much before the suit was instituted. And so, no right, title and interest in the suit property and had no right, title and interest in the suit property.
But I am also relying upon two judgments of Supreme Court.
Just a minute. This court is of the considered view that the learned first appellate court has considered this aspect of the matter, that there was no need to enter into the plea of readiness and willingness as the vendor had transferred his suit property. Date of agreement कब का?
25/1 5/9/1979
अच्छा एक second.
for 2 years. Everything has been done within 2 years, including filing of suit.
Yes, the plea of readiness and willingness could not have been simply declined on the ground that the suit property was already transferred. In view of the substantial question of law which essentially deals with section 19B
Yes.
of the specific relief act, this particular substantial question of law does arise for consideration as to whether the plaintiffs were ready and willing to perform their part of contract in the light of section 16(1)(c) of the specific relief act. ठीक है, अब एक सेकंड, बहुत लंबा डेट नहीं, आप कल पढ़ सकते हैं. You see, we have utilized the entire day for this. जब substantial question of law frame होता है तो आप लोग बिल्कुल भी केयरफुल नहीं रहते कि आप क्या substantial question of law बनवा रहे हैं. उस वक्त ना जजमेंट्स पढ़ने का ज़रूरत है, ना रिकॉर्ड्स पढ़ने का ज़रूरत है, एंड वी आर स्ट्रगलिंग टू फाइंड आउट आप लोग क्या करते हैं. व्हाट इज दिस? इज दिस द वे यू असेस द कोर्ट एट द टाइम ऑफ फ्रेमिंग ऑफ सब्सटेंशियल क्वेश्चन ऑफ लॉ? हम इसमें टाइम नहीं देंगे. यू सी, वी हैव यूटिलाइज मोर देन 3 hours. जितना रिकॉर्ड आपको पढ़ना है आप पढ़ लीजिए, लेकिन इसको हम टाइम नहीं देंगे. हम आप जो है कल आप इसको कंक्लूड करें. इतना कॉम्प्लिकेशन लाइफ में नहीं रख सकते. You just tell me, is it not your responsibility to assist the court at the time of framing of substantial question of law? And is it not your responsibility to point out any additional substantial question of law at the threshold? 3 घंटा बाद आप लोग एक नया substantial question of law, इतना clinching है वो substantial question of law कि हम ignore नहीं कर सकते हैं उसको.
कल तो हमको मिला तो हम सबसे पहले यही वाला.
तो क्या कर रहे थे इतना देर से बैठकर? 10:30 बजे से?
The file has come to us.
तो क्या करें? आपको घर में फाइल पहुंचा दें आपको? Please do not ever tell me this. फाइल नहीं मिला, ब्रीफिंग नहीं हुआ. आपका बेटा ब्रीफ कर रहा है, आपको कौन चाहिए ब्रीफ करने के लिए? नहीं, I will not take this. I should not be saying this. He is just a junior. But ये सब कोई कहानी है आपका.
I am not making any excuse.
We are not. कल आप बहस करिए, आप इसको हम इतना सुनने के बाद अब हम इसको बस अब जजमेंट लिखाएंगे कल. नहीं कुछ नहीं.
But एक रिक्वेस्ट, कल नहीं परसों.
खाली परसों
कल ही कर दिया,
Right?
या तो कल नहीं तो फिर
आप बात कर रहे हैं, हम तो बात कर रहे हैं,
नहीं हम
बट हम परसों कर, परसों
नहीं आप करिए, ये तो परसों नहीं है।
तो इसीलिए ना प्रॉब्लम है, नहीं तो
नहीं आप कर लीजिए ना, आप एक बात बता दें, नहीं तो अभी से सारा एविडेंस पढ़ाना शुरू करेंगे तो कल तक ऐसा नहीं करिए। और आई टेल यू वन थिंग, मोटा मोटी इम्प्यून जजमेंट से प्लेस करें, बिकॉज इट इज नॉट, आज के दिन में आपका ओरल एविडेंसेस को बहुत ज्यादा अप्रिशिएट करना इज ऑल्सो नॉट प्रॉपर,
it is not proper unless it is perverse.
अनलेस इट इज पर्पस, ऐसा तो
That
कुछ
is
है
what the
नहीं,
Supreme Court says.
ठीक है। तो आप अपना जो आपके इसमें मटेरियल में डिस्कशन है ओरल एंड डॉक्यूमेंट्री एविडेंसेस का, आप उसी पर आप इसको
ठीक है, हम परसों नोट्स कंक्लूड करें, हम छोटा सा रिटन नोट भी दे देंगे,
नहीं,
इस पे जजमेंट पे
परसों-
रिलाई करें वो भी दे देंगे,
नहीं,
बट ये कर ले इनको नोट्स अगर
अच्छा
कल
कल हम तो कर
ये कर ले ना, हमको खाली परसों कर
I have difficulty.
आप लोग इतना प्लीज डोंट डू दिस सर्विस टू आवर स्टेट कि इतना कैजुअली आप लोग जो है सब्सटेंशियल क्वेश्चन ऑफ लॉ पे ध्यान नहीं देते हैं और कुछ भी बन जाता है और हम लोग फंस जाते हैं। हाउ डू वी इम्पार्ट जस्टिस टू द लिटिगेंट? दिस इज अ वेरी सीरियस कंडक्ट क्योंकि सब्सटेंशियल एक का तो आपका सेल डीड वैसे ही खत्म है, एक सेल डीड तो आपका खत्म है, आप देख रहे हैं ना, unless you are able to
unless I am able to prove
yes
that.
yes certainly
मतलब
That-
I am
that
I am
rider is
able to
there.
not disprove that
that
I had knowledge.
that rider is there.
Yes. But anything
rider is
from
there.
your lordship will have very serious impact on that right now because कि एक सेल खत्म है लॉर्ड,
नहीं खत्म है मतलब
unless I don't prove
वो इसीलिए आपका सेक्शन 16 का बना दिए क्योंकि that is also a very important
important.
ingredient which the appellate court has refused to enter into. ठीक है, आप क्या आपको कहाँ ऐसा जाना है कि कल आप कौन सा कोर्ट में बिजी हो गए?
कल नहीं
परसों। क्या
परसों
problem?
नहीं है, हम है ही
कल
अब इसीलिए तो कल ही हम प्ले कर रहे हैं।
आपको क्या परेशानी है?
कर लेंगे ही।
नहीं हम नहीं कर सकते नोट्स, हम इसीलिए बोल रहे हैं, नहीं तो हम तो अपने नोट्स इनको सुबह भी हम फोन किए थे इसके लिए कि हम अगर करना है तो या तो परसों करते
कल हम
हैं।
लोग 10:30 बजे कुछ मैटर रखेंगे। साढ़े 10 बजे
कल 10:30 ठीक है ठीक है। ये लो चिप
आपको मनो आइए, नहीं मनो मत।
नहीं
हम आज हम रिकॉर्ड कर लेंगे जो भी होगा, हमको खाली परसों हमको 10:30 बजे कर लेंगे
एंड बी
परसों
वेरी
reply।
प्रिसाइज
अपने सही से इसीलिए बोल रहे हैं
क्योंकि ये वाला तो
अभी
हो
जो
गया
फ्रेम हुआ उसके हम बता रहे हैं क्यों ये कर रहे हैं। Your Lordship has already taken note that 1980 itself written statement was filed by one of the defendant in another suit. Only one payment was on 21/2/1980. Rest 4 payment are of the year 1981. So
तो
therefore
दिखाइए।
all these
7.81 तो
all
दिखाइए।
these receipts which are post
एक चीज
1980
दिखाइएगा ऊपर that except the payment of rupees 10,000
No, 5,000.
10,000 initially at the
हाँ।
time of registration of sale deed, all the remaining payments with in connection with the sale deed is of the year 1981. Is that correct?
Except one.
एक
एक पहले
Except
है।
one of rupees 5,000
yes
in
all
connection
other
with exhibit
A.
A, which is dated 5,000 का payment
For 21 to
21 to 1980
21
Yes.
to 1980.
all are in the year 1981. This therefore your Lordship, this is the portion.
बहुत
Whether they
टेक्निकल
can-
लॉ है ना, आप इससे कैसे कर सकते हैं? मतलब हमको कभी कभी बहुत हमको अफसोस होता है, पता है एक केस हम इसलिए डिसमिस कर दिए क्योंकि सब्सटेंशियल क्वेश्चन ऑफ लॉ में आंसर किए इन फेवर ऑफ द लिटिगेंट बट देयर वाज अ कॉन्करेंट फाइंडिंग ऑफ फैक्ट ऑन लिमिटेशन एंड आई हैव टू डिसमिस द सूट अल्टीमेटली concurrent finding on limitation and there is no substantial question of law on limitation. CAV हो गया, I had no option. कितना सीरियस बात है ये?
But your Lordship, during hearing your Lordship many a times, that is the reason that 105 says that your Lordship during hearing if your Lordship Honorable Court finds any substantial then it can. Therefore that particular power has been.
अब क्या करेंगे, इसका
But-
तो
but
पूरा
we
पढ़ना
cannot-
पड़ गया है, मतलब
but we
हमको तो
cannot-
लगता है कि हमको मास्क लगा के ये सब यूज करना पड़ेगा। ये सब फाइल खोलना आसान है क्या? छूते हैं तो जहाँ छूते हैं वहाँ फट जाता है। अब सोचिए, जस्ट थिंक ऑफ इट, इसको स्कैन करने नहीं दे सकते, आधा पूरा चिचड़ा निकल जाएगा इसका। इट इज नॉट पॉसिबल। ठीक है, कर लेंगे। और मिस्टर राहुल, आप अपना बहुत प्रिसाइज रहिएगा प्लीज, एकदम।
हम 15 मिनट से ज़्यादा। I have understood what two queries I have to meet and answering directly.
Sorry, आज थोड़ा लिखिएगा इसमें। लिटिगेंट को देख के ये सब करना पड़ता है, बिकॉज ऑफ द लिटिगेंट। ही इज एट द सेंटर स्टेज, ना आप है ना हम है, हु इज देयर?
डेफिनेटली बट 50 इयर्स से पोजीशन में है, हम लोग रह रहे हैं अब के बाद
तो देखना पड़ेगा ना, हर चीज देखना पड़ेगा।
40,000 में 1,000 दिए हुए कंटेस्ट
बहुत कुछ दिखाई। Now your Lordship, specific relief act was amended for this particular reason itself.
2018
Now there is
amendment
absolutely no discretionary remedy with it. It has to be specifically performed if there is a contract.
ठीक है,
So all these
That
interpretations.
is 2018 amendment.
ठीक है।
We will argue that also.
Item 2, second
Argue
73 of
कर लिया।
1997.
हमको तो बस यही है कि ये सब हम लोग कुछ करेंगे तो हम लोग का कुछ जाके क्रिस्टलाइज होगा,
हाँ वो
नहीं तो फिर कुछ ही नहीं होगा। जो भी हो, राइट हो रॉन्ग हो, हमसे जो भी गलती हो, तो दे यू हैव एन ऑप्शन टू गेट इट रेक्टिफाइड। हाँ, यस मैडम। टाइम के अलावा क्या चाहिए आपको?
Appellate number 1 died. Yesterday we came to the.
आपको कल ही पता चलता है ये 97 का केस में।
उनकी वाइफ आके बताई कि मर गया एक वीक पहले जस्ट, so we have to find substitution.
कब डेथ हो गया?
कल yesterday वो
आई थी बताने, आपने डेट ऑफ डेथ नहीं पूछा उनसे? इसके लिए क्या दूसरा कोई आएगा?
1 week पहले।
कब डेट? 1 वीक पहले हुआ है। सो
और
अनफॉर्चुनेट।
उनके एक बेटा दिल्ली में रहते हैं, तो वो हाथ
इतना दिन से सिर्फ टाइम हो रहा है और कॉस्ट हो रहा है इसमें। कम से कम जीवित रहते तो उनका काम कर लेते। फीस लिए थे ना उनसे, क्या कर रहे थे? रोज कॉस्ट हो रहा है इसमें। What kind of services are you rendering to your litigant? 24 में 1,000 रुपए कॉस्ट, ये सब टाइम चल रहा है। सभी मर जाते, फिर इसमें क्या जरूरत था? all of them would have expired. एक हफ्ता पहले डेथ हुआ, लिखे हम ये बात। डेथ सर्टिफिकेट के बिना आपका ना सब्स्टिट्यूशन अलाउ नहीं करेंगे। एक हफ्ता पहले डेथ हुआ। Are you serious about it?
मुझे सीनियर ने यही बताया।
नहीं, सीनियर को बुला के लेके आइए।
Yesterday आए थे उनके घर पे, तो बताया।
सीनियर को लेके आइए, स्टेटमेंट रिकॉर्ड करा रहा है कब डेथ हुआ।
सीनियर को भी नहीं है।
पूछ के बताइए, आस्क हिम। भाई बंदा आया, आपको सब्स्टिट्यूशन का सारा डॉक्यूमेंट दे के गया?
नहीं, वो वकालतनामा हमको कल ही हैंडओवर किए, तो वो बोले कि हमको 4 वीक
1 साल समय चाहिए।
4 वीक बोले, क्योंकि दिल्ली में उनका एक बेटा रहता है।
डेट ऑफ डेथ बताइए मैडम, नहीं तो हम केस एडजर्न नहीं करेंगे। डेट ऑफ डेथ
वो तो अब मुझसे ही पूछना।
डेट ऑफ डेथ का बहुत रेलेवेंस है। एटी 88 का सूट है। आपका जन्म हो गया था तब? नहीं हुआ था ना? आपके जन्म के पहले का केस है। थोड़ा सोचिए इसके बारे में। हो गया था हमको तो नहीं लग रहा कि चलो यू लुक सो यंग। Second appeal number 73 of 1997. Counsel for the appellant submits that the appellant number 1 has expired and she has received instructions to file appropriate petition in this case. At her request, pose this case on September 8th.
Item 4, second appeal 189 of 2004.
Yes, please.
Notices have validity, sir, lordship, according to office report, lordship.
तो क्या करना, बहस करिए ना, बहस करने के लिए मैटर।
Any date may be fixed.
Any date, आज ही का डेट।
Any date. Next week.
Any date.
Any date may be fixed, lordship.
ये क्या डेट आपको चाहिए? आपको पिछली बार आप ही के लिए टाइम हुआ था ना?
नहीं तो नोटिस हुआ था लॉर्डशिप.
What is the last date in this case?
नोटिस हुआ था.
When was it listed last? हमको याद है कि आपके लिए केस एडजर्न हुआ था आपके ग्राउंड परसों की तरसों।
नहीं तो बहुत दिन के बाद ही लगा. लास्ट हुआ था 29/7/2024 लॉर्डशिप.
दूसरा रिकॉर्ड।
अब दूसरा केस.
Notice has been validly served.
Yes. According to office reports, lordship.
The learned counsel for the appellant has submitted that as per office note, notice has been served upon the service of notice is complete either through the concerned respondents or through their close relative. यही है?
जी.
Any objection? Then it comes and he submits that the notice may be accepted as validly served. The learned counsel for the respondent number 1 has no objection with the prayer. Considering the aforesaid submission, the notice upon the respondents is accepted as validly served and is complete. Substantial question of law बताइए.
Order number 8 lordship 18/2/2009 lordship. Whether the learned court of appeal below has misconstrued and misinterpreted the judgment passed in partition suit number 11 of 2002.
Pose this case for final hearing the afternoon.
अगले सप्ताह कीजिए लॉर्डशिप.
अगले सप्ताह नहीं करेंगे. चलिए.
सोमवार को रख दीजिए.
Rejected.
सोमवार अगले
नहीं,
सप्ताह.
prayer rejected. Substantial question of law देख लिए. बस माइंड मेकअप हो गया. उस एग्जिबिट को पढ़िए और अपना पेश करिए. Supplementary list में डाल दीजिए.
Item 5, second appeal 1 of 1999.
Yes, appellant. क्या चीज़ की है?
ये अपलाट नंबर 1 है लीगल देवी इसका ध्यान रखना है और रिस्पोंडेंट नंबर 1 तो देन रिस्पोंडेंट नंबर 12 राम नारायण भगत एक आइए फाइल की थी फ्राइडे को किया आज कट गया इसका तो 3 प्रेयर के एक का नाम में करेक्शन है एक का नाम डिलीशन है और एक का सब्स्टिट्यूशन है
नाम में करेक्शन है.
हाँ एक नाम में करेक्शन है
आपको क्या बोलना है?
इसमें जो देख करके हम सब्स्टिट्यूशन फाइल
ये सब्स्टिट्यूशन फाइल कर देंगे उसी दिन करेक्शन कर
हाँ उसी का ठीक है
ठीक है ना?
आइए को आइए डिस्पोज अपने किया जाए कहीं वकालत में सब फाइल की बात तो उनका जब अलाव हो जाएगा
डिस्पोजल कर देंगे ना. आइए क्यों पेंडिंग रहेगा? आपने इन्फॉर्मेशन दे दिया, बात खत्म हो गई. और किसका नाम आपको चेंज करना है?
मेरा नाम prayer number 3 दिखा रहे हैं that the petitioner further prays that the name of respondent number 1 namely Sangeeta Devi be substituted as Usha Devi as her name has wrongly been mentioned as Sangeeta Devi in first title of name of appeal. Earlier substitution हुआ था वो संगीता देवी हो गया था लेकिन उसका नाम उषा देवी होना चाहिए.
ऐसे सब्स्टिट्यूशन इस तरह से कैसे कर सकते हैं? नाम चेंज अब संगीता देवी को हम उषा देवी बना दो सही
उसका नाम उषा देवी.
ऐसे कैसे आपको कोई
अच्छा
पर्सनल
हम उसका वो आधार कार्ड लगाए थे.
आधार कार्ड से क्या
She is the daughter and her name
कहाँ क्या क्या चीज़ से आपको प्रूव डॉक्टर क्या चीज़ से प्रूव हो सकता है दैट शी इज द डॉटर?
ताकि अब तो शादी भी हो गया तो हस्बैंड का नाम है आधार में.
10वीं का सर्टिफिकेट चाहिए
हाँ 10
या अनपढ़ है?
पता कर लेते हैं.
इससे कैसे आप लोग इस तरह से करते हैं? सब्स्टिट्यूशन एक बार हो चुका है पहले. कौन सब्स्टिट्यूट किया था? आप किए थे सब्स्टिट्यूट?
नहीं एप्लेट किया.
हमें उसमें इनको ऑब्जेक्शन करना चाहिए था. अगर गलत हुआ है तो ऑब्जेक्शन करना चाहिए था.
6/6/2011 को हुआ है. एक्चुअली अभी वो डिटेक्ट किए तो बोले तो
सब्स्टिट्यूशन इनको बिना नोटिस के हो.
हाँ लोग बिना नोटिस के.
आपको उन्हीं का एफिडेविट फाइल करना है, किसी और का एफिडेविट नहीं चलेगा. क्लास 10 का सर्टिफिकेट के साथ में रहेगा.
अच्छा कुछ
बिना क्लास 10 का सर्टिफिकेट का नहीं होगा. ठीक.
बैठ के सर्टिफिकेट.
तो ये तो अभी यहीं पर हैं आपके लिटिगेंट. कहाँ के हैं? रांची के हैं. बस इसको परसों फाइल कर दीजिए. ऐसे नंबर 1 of 1999. The learned counsel for the parties are present. The learned counsel for the respondents on instruction of his client prays for 2 days time to file supplementary affidavit to IA number 10751. पोस्ट ऑन थर्सडे. उसके बाद आपको टाइम देंगे. आप भी ले लीजिए इंस्ट्रक्शन.
जी.
From date list for final disposal, item 6, second appeal 352 of 2016.
Yes, please. आप रेडी?
Yes.
Yes, आगे. What is the point of law?
Yes. Earlier on, the substantial question of law was the film matter. That substantial question of law is not tenable matter. Agent.
Not tenable मतलब? Infractus हो गया केस?
नहीं हो. कारण जो कि उस समय मुझे गलती हुआ जो कंप्लेंट देखे नहीं थे और उसमें एट द टाइम ऑफ आर्गुमेंट डेट का रिलीव पोर्शन में अमेंडमेंट हो चुका था. तो इसलिए हम सब्सटेंशियल क्वेश्चन ऑफ जो फेल हुआ as per amendment my lord, the substantial question of the substantial question of
पढ़िए जरा क्या बनाया है.
so whether in view of the section 31 of the Specific Relief Act, unless and until a sale deed is declared null and void by a court of competent jurisdictions, it shall not be deemed to be cancelled by a deed of cancellation and only be executed if it is not declared the deed null and void by competent court.
रेल में क्या चाहिए?
बाद में पहले रिलीफ पोर्शन में चीज नहीं था. At the time of argument this was amended my lord.
At the time of argument, where before the trial court,
Before the trial court.
the suit was amended.
Relief portion was amended.
So that is not amendment of
Amendment.
suit.
That is the amended my lord. That is
What was the amendment carried out?
amendment my lord was the
Plain दिखाओ. That where was
plaintiff, my
included.
lord, the short note at the time of the argument my lord in the plaint for declaration of
At the time of
shall deed.
argument कैसे हो सकता है कोई भी plaint का amendment? ऐसे argument पर कैसे हो सकता है? Unless there is a petition filed for amendment.
हाँ फाइल हुआ. At the time of argument, amendment petition was filed and amended, and the plaintiff they sought relief for declaration of the sale deed. They
So
executed
this
in
question
favor
of law does not arise now.
Therefore, my lord, therefore,
So what?
therefore, my lord, I am proposing, my lord, the new substantial question.
What substantial?
The additional substantial question of law, my lord. If my lord, they permit, my lord.
We will not permit this. We will not permit. What is this? So irresponsible. What is this? बिना देखे बिना समझे कुछ भी फ्रेम करवाते हैं.
मेरे पास
पांच तो पांच सब्सटेंशियल क्वेश्चन ऑफ लॉ बना देते हैं, उसमें से बस एक टिक मार के करवाते हैं.
नहीं,
फिर क्या?
मेरे पास जो प्लेन था हुजूर उसमें अमेंडमेंट नहीं था हुजूर, इसीलिए
आपके पास प्लेन था, लिटिगेंट से नहीं पूछते हैं. लिटिगेंट से कोई नाता रिश्ता नहीं है आपको.
इसीलिए इसी ढंग से गलती हो गई.
सेकेंड अपील में लिटिगेंट खुद आके ब्रीफ देके जाता है. ये आप हमको मत बताइए. ये क्रिमिनल अपील नहीं है ना, लिटिगेंट नहीं आता, लिटिगेंट खुद आता है सेकेंड अपील में. This relief was always there. It is not a new amendment.
This is new amendment.
No,
Yes.
no.
The earlier my lord.
What was the relief earlier? दिखाइए आपका plaint दिखाइए. Please show it to me.
relief देखा जाएगा.
आप पढ़िए. आप अपना पढ़िए.
हम पढ़ रहे हैं. That the right title for suit land be declared in favor of the plaintiff and the order dated 25/1/2002 passed in case number such and such. The 125 the CRPC be declared the erroneous, the void and cancelled. That if any sale deed executed by the defendant number 1 in favor of defendant number 5 and mutation order passed in favor of defendant number 5 be declared the null and void and not binding against the plaintiff.
Right तो है ही आपके पास.
There was no relief, specific relief model. What sale deed you want
That's
to
right.
for the
That's
declaring
right.
in
They
null and
must have
void
come
manner.
up with the same deed.
Thereafter, Manot, thereafter, Manot, the plaintiff Manot, they filed the amendment petition Manot for declaring sale deed null and void Manot. And although Manot, that sale deed was not brought in record Manot by the plaintiff. No such issues were the framed Manot regarding the declaring Manot the null and void of the deed Manot.
This deed has been declared null and void.
Null and void.
By which finding? Show us.
Yes, Manot.
Where is that?
Appellate court, Manot, the judgment, Manot. Without giving finding Manot, the simply the order passed Manot, the page 37 Manot. Appellate court judgment Manot, the page 22. No such specific finding has been come was given Manot by the appellate court malot, whether in lastly malot the order passed by the appellate court malot page, running page 37 malot. The appeal has got the merit, hence they allowed. And
कहाँ से कौन सा पैरा पढ़े हैं?
last order part malot. Order sheet का appellate court order का internal page 22 देखेंगे review. Last जो order
22
22.
पढ़ी?
This appeal has got merit, hence they allowed contest with cost. The judgment and decree passed by the learned Joseph Bumla is hereby satisfied. The right title interest over the suit property on the basis of the said deed number 861 dated 7593 of the appellants is hereby declared, and the said deed is the legal binding and effective unless and until it is declared null and void by the court of competent jurisdiction. The appellant on the basis of said deed come in the possession of the suit land from the date of purchase of the land, and the said deed executed by defendant number 1 Firu Rodia in favor of original defendant
ये
number 5.
96 वाले सेल डीड का 93 वाले सेल डीड से क्या लेना देना?
93 वाला the said deed was
Was
executed by Nanhu Rotia, who is the father of defendant number 5.
एक सेकंड 93 वाला सेल डीड is executed by
Defendant number Nanhu Rotia, who is the recorded tenant my lord, who is the also
डिफेंडेंट नंबर बताइए ना
who डेथ कर गए उनके बेटी.
भाई कौन किसके रिलेटिव है
डिफेंडेंट नंबर 4 का फादर है और डिफेंडेंट नंबर 1 and 3 के चाचा.
डिफेंडेंट नंबर 4 के फादर एंड
1 and 3 के 1 2 3 के चाचा.
1 2 3 के अंकल. They executed the defendant of this sale deed of 1993 in favor of whom?
In favor of the father of the plaintiff.
और 96 वाला डेट से
96 वाला they executed by defendant number 1 in favor of defendant number 5 Jewel 2.
What is the date of the trial court judgment?
Trial court judgment my lord passed on 4th of February 2010. Even there was no issue my lord before both the courts my lord for declaring the said deed, they declare null and void my lord. And there was no such documents they brought by, there was no said deed, which was the letter on which was under challenge my lord, they not brought in record by the plaintiff.
आप plaintiff है, defendant है.
हम डिपेंडेंट हैं।
आप खुद ही बोले ना हमको written statement देना है ना कुछ करना है. The amendment was allowed on 16/1/2010. It is your submission, recorded. While allowing the amendment.
हाँ, that amendment was allowed.
Allowed, and you say that I don't want to give any
हम
further
नहीं,
written statement.
हम उसमें हम नहीं बोल रहे हैं। हम amendment को challenge हम नहीं किए हैं। I'm not objecting the amendment petition, my lord. Only says, my lord, कि don't have knowledge, my lord, about the amendment, my lord, and therefore.
Second appeal number 350. आपको क्या बोलना?
Much of the appellate court judgment is well defined, and regarding the issue of second safety, that has also been dealt in para 36.
No, but substantial question of law is absolutely
Yes,
incorrect.
sir, it is certain.
दूसरा भी substantial question को सुन लीजिएगा।
नहीं, अब ऐसे नहीं
नहीं, तो
ऐसे number 352 of
there is
2016.
there is liberty, my lord, to
What
propose this other substantial question of law, my lord, at the time of argument. My lord, this suit was also the time barred, my lord. It appears from the evidence of the plaintiffs itself. Therefore, my lord, can you allow, my lord, to propose this other substantial, additional substantial question of law, my lord? Therefore,
The suit was time barred
yes, ma'am.
with respect to this 96 deed.
Yes, ma'am.
When was it executed? Date? Date of execution.
Date of execution, my lord, 15/7/96.
When was the suit filed?
The suit was filed, my lord, 2002, my lord. 2003, my lord. 2003, my lord. Plaintiff का evidence देखेंगे which is paragraph 38 and 40, my lord.
Issue number 3 को lordship limitation क्या है? That has also been dealt very carefully.
Please, sir.
Through running page 34 lordship of appellate court judgment. Para 43 lordship.
Yes, please read it.
Para 43 lordship. Issue number 3. At this juncture, I have gone through the impugned judgment and decree passed by the learned motion, and on careful consideration of the same, I find para 27 of the impugned judgment that the learned Munshif had discussed this issue, and on careful consideration of the same, I find the learned Munshif had decided this issue against the appellate, only on the ground that it has come in evidence of the appellates that there is a dispute regarding properties just 2 to 3 years after purchase of the land. The learned Munshif further held that the suit has been purchased in the year 96, and so the dispute is in between the parties from 96. He further held that it has also come in para 12 of evidence of PW5 that the case is going on in between the parties for last 10 to 12 years, and the appellant was deposed on 23/2/2007. Therefore, the learned court held that there was a dispute in between the parties since 97, and whereas the appellant plaintiff filed the suit in the year 2003 for declaring the sale deed of 96 as void, the learned Munshif held that the suit is barred by law of limitation. In light of the aforesaid findings, and I have gone through the evidence which I have discussed in the aforementioned paragraph, then I find admittedly PW5, who is the appellant in para 36, admits that the suit property was not mutated in his name because the same was mutated in the name of Jewel Topo. But he further fails to say when the name of Jewel Topo was mutated, but the evidence of PW5 has not been considered by the court. Para 38 of evidence of PW5 has referred, in which he has deposed, there is a case in between the parties regarding suit property for 2 to 3 years of the date of purchase of land. And this evidence has been considered by the court below, and only on this basis the learned court below held that a dispute was going on in between the parties since 96, whereas the case has been filed in 2003. So the suit is barred by limitation. At this juncture, I would like to consider Exhibit G,
The order passed by learned executive magistrate in case number 1362 so and so proceeding under section 1245 CRPC.
Second appeal number
What is
352 of
this?
please hold on.
Paragraph 40,
No,
paragraph 40 of the evidence. Just allow
we
me to
will see
read the matter.
that. Yes, we have given you enough more opportunity. Essay number 352 of 2016.
एक बार खाली
The
पढ़
learned
लेते हैं हम
counsel-
तो एविडेंस लिमिटेशन पे वो क्या
Just
बोले हैं आगे.
heard the learned counsel for the appellant and the learned amicus. This case was admitted by the order dated 23rd September 2019 on the following substantial question of law. The learned counsel for the appellant has submitted that due to inadvertence, the aforesaid substantial question of law has been framed. In fact, the suit was amended challenging the sale deed dated sale deed number 1720 of 1996. And therefore, he submits that the aforesaid substantial question of law does not fall for consideration in this case. However, he has submitted that there is an additional substantial question of law which is involved, which is on the point of limitation. He has submitted that, which is on the point of limitation. The learned counsel has also submitted that the sale deed was of the year 1996 and the suit was filed in the year 2016.
2003.
Sorry, in the year 2003. And therefore, he submits that. He has also submitted that it is for the court to even to consider the point of limitation, which has not been properly considered. The suit having been filed, the suit was filed much beyond the date of execution of the sale deed, and therefore it was barred by law of limitation. The learned amicus has submitted that certainly the substantial question of law as framed does not arise for consideration in this case in view of the fair need in the suit itself. That sale deed was under challenge. So, and so far as the point of limitation is concerned, he has submitted that the learned munsif had decided the point of limitation in favor of the defendant, and the learned first appellate court, after elaborate consideration of materials on record, had decided the issue by issue number 3 and has held that that in its opinion the limitation would commence from the date of knowledge and on the basis of cause of action, which was supported by the evidences adduced on behalf of the parties, and held that the suit was not barred by limitation. The learned counsel submits that the learned amicus submits that the finding on the point of limitation is elaborate and well founded, and therefore there is no substantial question of law involved in this case. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and upon perusal of the plaint as amended, just please hold on, as amended, बस ठीक है, as amended, it is not in dispute that and also from the counsel of the appellant that the substantial question of law as formulated by the order dated 23rd of September 2019 does not fall for consideration. And so far as the point of limitation which is sought to be raised by way of additional evidence, this court finds that the learned first appellate court has elaborately discussed the materials on record while reversing the finding of the learned trial court on the point of limitation. And in view of considering the aforesaid facts and circumstances, this court is of the view that no substantial question of law on the point of limitation arises for consideration in this case. Accordingly, in view of the aforesaid circumstances, the substantial question of law as already framed by order dated 23rd of September 2019 need not be answered. And so far as the additional substantial question of law is concerned, this court is not inclined to frame that as no substantial question of law is involved. There is no perversity in the findings recorded by the learned court. Accordingly, this appeal is hereby dismissed. Learned amicus का appreciation, learned amicus का appreciation का record कर दीजिए, और साथ में उनको जो कोर्ट मतलब फीस मिलना है लीगल एड से.
And issues have not been framed regarding the